I'm ready, Miss McDermott. Excuse me, Miss Kelly. Since you changed your last name. Call this regularly scheduled Tennessee Real Estate Commission meeting back into session. And at this time, I'm going to turn the proceedings over to our Judge Steve Darnell, to continue and to give us instructions.
All right. Thank you, Chairman Stevenson. All right. Let me make an announcement on the record, then we'll begin with this matter. Today is March 7, 2013. This is a hearing before the Tennessee Real Estate Commission.
I don't think we can hear you.
Oh, I'm sorry.
It's on, yeah.
Am I not,
Okay.
am I not on?
You may have to turn your volume up on it.
They usually tell me to turn my volume down. Let's try that. Is that better?
It's better.
No?
They have to talk just a little louder, Judge.
All right. How's that? Is that better? Maybe I'm not close enough. All right. Let's go back on the record then. Today's March 7, 2013. This is a hearing conducted by the Tennessee Real Estate Commission, chaired by Mr. Bear Stevenson, to consider the case of Gase Hill, docket number 12.18-119922A. My name is Steve Darnell. I'm the Administrative Law Judge assigned by the Tennessee Department of State Administrative Procedures Division. I will sit with the board. As the Administrative Law Judge, I'll make all rulings regarding the order of proceedings, admissibility of evidence, and questions of law under the authority granted to me by the Tennessee Administrative Procedures Act. I will not participate in the findings of fact or the ultimate decision of this board. Those decisions be made by the commission members only. At this time, I'll ask the members of the Real Estate Commission to introduce themselves, and let's start on the far end there, sir.
Over Collins.
Janet DeChara.
Bear Stevenson.
Michelle Haynes.
Isaac Northern.
John Grease. Austin McMullen.
All right, and Chairman Stevenson, does this constitute a quorum of the commission?
Yes, Your Honor, it does.
Members of the commission are reminded that during the time this hearing is being conducted, no discussions concerning this case should take place between the commission members and witnesses, attorneys, other commission members, or other persons unless all parties are present. During the hearing, this commission sits as a jury and must only consider evidence introduced at the hearing in reaching its decision. The Sunshine Law requires all commission discussions and deliberations to be in public before all parties. Failure to observe the Sunshine Law may result in the commission's action being reversed or remanded if appealed to court. Commission members, you are reminded not to draw any conclusions until all the proof has been submitted. Please listen to all proof with an open mind. Before going further, I'd remind members of the commission that the law requires you to disclose on the record any outside knowledge of this case or any communications, written, verbal, or otherwise, with any of the parties that you may have had. And I'll also note that there's been a notice of charges distributed to the members of the board. And I'm sure I'm pronouncing Mr. Hill's first name wrong, but you all have had an opportunity to look at that. Does anybody have any outside knowledge of this matter? All right, let the record reflect that no one has any outside knowledge. All right, during the course of the hearing, there will be an opportunity for each of the commission members to ask questions of the witnesses as they testify. Let me caution you to use that opportunity to develop the factual issues that are relevant to the final determination of this matter, and your questions should be limited to that relevant evidence only. Relevant evidence is defined as evidence having any tendency to make the existence of any fact that is of consequence to the determination of this action more probable or less probable than it would be without the evidence. Sometimes issues come up that might pique our curiosity but are really not relevant, and if that occurs, I'll point that out to the board members. All right, Attorney Robin Ryan's present for the department, and Ms. Ryan, are you ready to proceed?
I am.
And who is your party representative today?
Eve Maxwell is the director of the real estate.
All right, and do you have other witnesses?
I had subpoenaed a Tracy Carpenter Smith who called me earlier this week and said she was coming, but I don't see her yet.
All right.
And then I'll be calling the respondent as an adverse witness.
All right, so Ms. Carpenter Smith is the only, and is Ms. Carpenter Smith present? All right. All right, Attorney Todd Jackson's present, represents Mr. Hill, and Ms. Jackson, you ready to proceed?
I am.
All right, And Mr. Hill's present. Mr. Hill, I have to apologize. Pronounce your first name for me, please.
Oh, it would be Gaius in Latin, but it's Gaius in the Greek.
Gaius, okay.
Yeah.
Which do you prefer, Greek or Latin?
Gaius is what I use.
Gaius.
I prefer the Latin, but my parents like the Greek. So.
All right. Well, we don't have a lot of
I'm
control
stubborn.
over those
I'm
things at
stubborn.
times. All right, so Gaius Hill is the correct pronunciation. All right, either party want to invoke the rule?
No.
All right.
Yes, sir.
All right, members of the board, you've had a copy of the notice of charges distributed to you. Has everyone had an opportunity to review that? Okay. Let's
I
take
have
just
not.
a few moments and look that over to give you a little understanding of why we're here today, and then we'll hear opening comments from the attorneys. All right, are we ready to proceed? All right, great. All right, opening comments, Ms. Ryan?
Morning. We are here today on the matter of Trek versus Gaius Hill, and this matter resulted from a complaint filed by Miss Carpenter Smith, who had a contract with Mr. Hill to manage her property located at 3413 Callias Circle in Antioch, Tennessee. She had several issues with Mr. Hill, but the matter here before you today concerns a security deposit paid by the person who rented the property through a contract with Mr. Hill. The proof will show that the deposit in question was paid at the beginning of the lease in September of 2011, and that Mr. Hill deposited that money into the Christian Realty and Development escrow account on September 13, 2011. As I said, the complainant had several issues, and the proof will show that she attempted to terminate the agreement with Mr. Hill on October 31, 2011, and first asked for that security deposit to be released on November 3, 2011. The proof will further show that respondent replied that as there was money due to the loss of services, and that he then asked for a termination fee, even though there was no such provision in the contract between these parties. Proof will show the complainant again asked for the deposit on November 15, 2011, and for a third time on November 21, 2011. Emails from Mr. Hill will show that, excuse me, there's a door opening on me. Emails from Mr. Hill state that she could not unilaterally terminate the contract and that he was owed money. Finally, on November 13, 2012, a check was issued for that security deposit more than 1 year after the request for the deposit to be released. In his response to the complaint, Mr. Hill stated he was owed money, and that he discovered the tenant, and after he discovered the tenant had left the property at the end of the lease, I presume, he then paid the deposit after he learned that Miss Carpenter Smith had to take that money out of her own account to pay when the tenant left. The state submits that Mr. Hill had absolutely no legal right to keep money belonging to that third party, and that after he was relieved, he should have released that money. He did not. And the state submits that 1 year later is not in compliance with 6213-312-5, which provides that it is a revocable offense if a licensee fails within a reasonable time to account for or to remit monies coming into his possession belonging to others. I suggest that such behavior is something that this commission should seriously consider. And at the conclusion, this commission should issue a money judgment, consider suspension until such time that money is paid, or even revocation, and that he be required to take some education and certainly pay all the costs in this proceeding.
Thank you, Ms. Wright. Mr. Jackson?
Good morning, Your Honor, members of the Commission. I'm Todd Jackson. Mr. Hill in this matter did exactly what he's supposed to do. He understands his obligations as a real estate agent. No time did the tenant request or approve or consent to any modification to his lease. I think the part that's missing in that introduction is the fact that this lease with the tenant is in the name of Mr. Hill or his real estate company, Christian Realty. Carpenter is the one.
Excuse me. We have some people up here that are having a hard time hearing you. If you could just speak a little louder and get a little closer.
Turn the volume button up.
It just keeps going off? I'm not talking loud enough. Okay. I'm sorry about that.
Have to lean into it a little bit.
Okay. The lease agreement, the obligations under the lease agreement are Mr. Hill's. He has an obligation to handle the security deposit, obligations under the lease for what happens in certain events. At no time did anybody ever offer to him an amendment to that lease with the consent from the tenant, any agreement or any documents requesting a transfer of any security deposit to another management company. If that would have been done properly, then he would have cooperated with that. But what he was asking, what he was being asked to do is violate the rules. So I would submit that if he would have done what he was asked to do, he'd be in here for a different reason, because he would have been violating the lease that he was obligated under and transferring trust money without the proper channels, without the consent of a tenant. And the charge that he's brought up on is failing within a reasonable time to account for and remit any monies coming into the licensee's possession that belong to others. I think Ms. Carpenter might be under the misconception that that's her money. This is the tenant's money, and at no time did he ask for that to be transferred. If he would have done that, Mr. Hill would have complied, because his obligations did not end under that lease just because Ms. Carpenter changed her mind and decided she wanted out of a contract that she was obligated under that called for a mutual termination, which did not happen. So, again, I submit that Mr. Hill did exactly what he was supposed to do under the rules, and that had he done what he was asked to do, he would have been violating those same rules. Thank you.
All right. Thank you, Mr. Jackson. Ms. Robin, what's your first offer of proof?
I call Eve Maxwell.
All right, Ms. Maxwell, if you'll take a seat over there across from our court reporter. All right. Raise your right hand. Do you solemnly swear or affirm to tell the truth and nothing but the truth, so help you God?
Yes, I do.
All right. Would you state your full name for the board or for our commission?
My name is Eve M. Maxwell.
Thank you, Ms. Maxwell. Ms. Wright?
Maxwell, what is your position with the state of Tennessee?
I'm the executive director of the Tennessee Real Estate Commission.
And as the executive director, are you familiar with both the license and the complaint files of Mr. Gaius Hills?
Yes, I am.
What is his license number?
His license number is 21873.
When was he licensed first?
He was first licensed on 1/18 of 1978 as an affiliate broker.
And is he now a principal broker?
He is now a principal broker. He got his broker's license on 5/6/1981.
Do your records indicate whether Mr. Hill did property management?
The state of Tennessee does not issue a specific property management license. If you have a broker's license, you can engage in activities that involve property management.
Do you have the copy of the complaint in question?
Yes, I do.
Have you looked at it recently?
Yes, I have.
What were the complainant's issues, or what did she state was issued? Well, let me ask this first, sorry. When was the complaint filed?
The complaint was opened on July the 19th of 2012.
And what were her issues in the complaint?
Her issues in the complaint, taken from the complaint information itself, was that she complained about inadequate services that were provided by Gaius Hill of Christian Realty, and as a property manager, he failed to provide reasonable and adequate services which were promised, and that he failed to return the current renter security deposit escrow check in the amount of $1,050 that was sent to the property management company when the complainant terminated the 12-month contract.
So is there a copy of the contract with the complaint file?
The management contract?
Yes.
Yes, there is.
And the management contract was between who and who?
The management contract was between Tracy D. Carpenter as owner and Christian Realty as manager.
And, sorry, she said I wasn't speaking loud enough. Can you believe that? Okay.
Hard to hear them.
Okay. And that was the management contract for the property in question. What was the property in question?
The property address is 3413 CALAIS Circle, Antioch, Tennessee 37013.
And in that contract, is there a provision that should the contract be terminated early, the Miss Carpenter-Smith had to pay an early termination fee?
No, there is not.
There's nothing provided for such in the contract.
No, there is not.
Okay. Was there subsequently a contract between the realty company and the tenant?
Yes, there was.
Okay. And what is the date of that contract?
The date of that contract is the 16th day of September 2011.
And was there a provision in that contract for a security deposit?
Yes, there was. There was a security deposit provision for $1,050.
Now, in the documents provided by Mr. Hill, did he provide a copy of the deposit slip for that deposit?
Yes, he did.
And when did he deposit that money?
The money was deposited on 9/13 of 2011, the amount of $1,050. It was deposited in the Christian Realty and Development escrow account.
Now, did the complaint reflect when Miss Carpenter-Smith attempted to release or terminate the contract?
She first wrote by email Mr. Hill on 10/31 of 2011 and stated that she wanted to terminate the agreement, and this was her notice, 30-day notice. On 11/3 of 2011, she again said she wanted to terminate the agreement and requested for a release of the security deposit. On 11/15/2011, she made a second request for release of the security deposit. On 11/21/11, she made a third request for release of the security deposit, and she indicated that she wanted it sent to her address.
Do any of the records reflect who took over the agreement between the tenant and the owner of the property?
She said, please release the security deposit to Parks Property Management, 8119 Isabella Lane, Suite 105, Brentwood, Tennessee, 37027.
Did he also provide in his documents a copy of when the check was finally paid?
Yes. It was, there's a cashier's check made out to Tracy Carpenter Smith dated November the 13th of 2012 for the amount of $1,050.
That was,
And the customer receipt shows that it was purchased by Christian Realty Escrow from Fifth Third Bank. It was a cashier's check on November 13th of 2012 with the payee being Tracy Carpenter Smith.
that's after this complaint was filed?
That is correct. The complaint was opened in July of 2011.
And 2011?
The complaint was 2012. I'm sorry, July of 2012.
And the first request that, go back to the first time she asked for that money to be released was what date?
The first time that she made a request for release of the security deposit was November the 3rd of 2011.
So that was over a year later that it was finally paid to her, and after this complaint was filed.
That is correct.
But what did Mr. Hill respond to this complaint? What was his excuse?
Mr. Hill he filed a response to the complaint that was received by the Tennessee Real Estate Commission on August the 8th of 2012. In that response, he set forth a timeline that appeared to correspond with Ms. Carpenter's timeline. He states in his answer, the problem arose when Tracy Carpenter sent me an email attempting to terminate our management agreement with no compensation. I had spent hours outside the normal scope of management advising her on the repairs needed and was counting on management fees to compensate us for this and the inspection trips that we made. Do you want me to read the whole answer?
Well, does he address anywhere the security deposit?
No, he just says that the problem arose when she wanted to terminate the management agreement with no compensation.
And again, was there a compensation provision in the contract?
No, there was not a termination compensation agreement.
Did he didn't say then why he was keeping the security deposit of a tenant that he was no longer managing?
He did not specifically reference the security deposit in his answer as far as the reason why he was keeping it.
Did he file subsequent documents with a timeline?
Yes, he did.
Okay. And on the second page, again, about repairs, what did he say?
The problem arose when Tracy Carpenter, he said, I spent many hours outside the normal scope of management with no advising her, Ms. Carpenter, on repairs needed and was counting on management fees to compensate us for this and the many inspection trips we had made. She insisted on making repairs herself. After all, my name is Carpenter. However, she was very slow to make repairs and took weeks to move her personal belongings out of the garage. This resulted in many hours of dealing with an unhappy tenant and many inspection trips to see what work had been done and when work was finished. I believe that our insistence on these repairs being made, which we had promised to the tenant, was the start of her dissatisfaction with our company.
If you would look again on this document that Mr. Hill provided in this timeline.
Correct?
If you could read from 9/13/2011 to 11/15/2011, what communications he lists as communicating with the tenant himself? Just that he had with the tenant himself. Yeah, just with the tenant himself.
On 9/13/2011, he received the deposit check from the tenant made out to Christian Realty in the amount of $1,050. On 9/14/2011, he received a call from the tenant, met with him, and the tenant was told Mr. Hill that his present living quarters were no longer viable due to a dispute with girlfriend who owned the premises where he was staying.
And if you turn the next page.
Oh. Did you want me to go on?
No.
Okay.
Unless there's other communications
There
with him on that
were,
page.
There was one other communication on 9/17/2011. Received word from Mr. Gray that $525 check had been written on wrong bank account and instructed not to cash. His replacement was forthcoming. That was a prorated rent amount.
And so from 9/17, the other listings of 9/22 up through 11/15/2011, any notes of any communication with the tenant?
No, there were not.
And the next page?
On 11/13/2012, this is the next date listed on that timeline, reached Mr. Jeffrey Gray after many attempts and was told he had moved. Also discovered that he received a return of deposit from Tracy Carpenter Smith. Bob Parks Realty said Tracy Carpenter Smith had written a check for return of deposit.
So after many attempts and was told that he was moved, that's what he said?
That's what he said, was
So
told.
is there any indication that he was acting as a property manager in any way subject to that contract prior to that date? Any communications?
Not since the one that I read earlier.
What do the real estate law, broker's law, require concerning monies belonging to others?
The real estate law, there are several provisions that require money belonging to others to be deposited in an escrow account. There's a rule 1260-02-.09 that requires that there be a separate escrow account for holding funds which may be received in fiduciary capacity as deposits, earnest money, or the like, and rental deposits must be held in a separate account. Brokers are responsible at all times for the deposits and earnest money. And the funds in escrow account shall be dispersed in a proper manner without unreasonable delay. They should be dispersed or interplayed within 21 calendar days from the date of receipt of a written request for disbursement of earnest money, and that's all in the rule. And the statute, the Brokers Act, the Tennessee Real Estate Brokers License Act of 1973, has several provisions as well. One is found in 6213-312-5, with which is prefaced by the opening part. The Commission shall have the power to refuse a license for cause or to suspend or revoke a license where it's been obtained by false representation or by fraudulent act or conduct, or where a licensee in performing or attempting to perform any of the acts mentioned herein is found guilty of failing within a reasonable time to account for or to remit any monies coming into the licensee's possession which belong to others. And then there's a duty set forth in 6213-403, number B6, which requires timely account for trust fund deposits and all other property received from any party to the transaction.
Now, he did deposit this money into an escrow account.
It appears that he did, yes.
But that money was not released until over a year after it was requested.
That's correct.
Okay, and the property management agreement was between Mr. Hill and Ms. Carpenter Smith, is that right?
That is correct.
For property owned by Ms. Smith.
That is correct. Miss Tracy D. Carpenter is listed as the owner and Christian Realty as the manager.
And then the tenant agreement was between between the Mr. Hill and the tenant.
The tenant agreement was between, yes, the tenant as resident and Christian Realty property management as manager.
But was there any provision in there that he was an owner, or that he could stop or keep security deposits separate in different from the contract itself relating to property owned by another? Did he have any right to do what he did in that contract?
The contract doesn't make money collected that belongs to the owner or the tenant, the property managers.
But if you read the section about the security deposit, what does it say about that?
The security deposit, less deductions for damages or cleaning, shall be turned to resident only after the following conditions are satisfied. Do you want me to read those? Or okay. The lease must have expired in accordance with its terms without default by resident, and resident shall have vacated the property on or before the termination date. Resident shall have given the required 60 days written notice to management. Resident shall have left a forwarding address with management. The property, including all kitchen appliances, shall have been cleaned thoroughly by resident. Management will inspect the premises after resident vacates to ascertain if resident caused any damage that exceeded normal wear and tear, and will notify resident of such damage. All keys, garage door openers, and other electronic devices, if applicable, must be returned. Resident must maintain lawn care. Resident agrees that if any conditions are not satisfied, management may deduct from the security deposit said costs in applying any remaining balance to rents due under the lease agreement.
Now, as indicated earlier, Ms. Carpenter-Smith attempted to terminate the property management agreement in October 31st of 2011. Is that what you said?
That is correct. That was when she emailed the first notice.
Okay. And she asked for the deposit to be returned and paid to another company. Is that right?
That is correct.
And there's nothing in the file to indicate that somehow Mr. Hill's company collected the rent, managed the property after termination of the property agreement, is there?
No, there is not.
And again, even though he was asked, his excuse was they were owed money and he wanted compensation for early termination?
That is what he stated, that he wanted to be compensated.
Is there any provision in the law that allows a broker to keep deposits when he or she is owed money by the other persons?
No, there is not.
Did the property management agreement allow Mr. Hill to keep the security deposit?
No, this property management agreement did not allow for the security deposit, which belonged to a third party.
And was there a provision that did allow the contract to be terminated within a year? Excuse me. I'm supposed to apologize for all the noise, and the standard line is they're working on my office. So ignore the noise, if you can.
Could you repeat the question, please?
Yeah, if I can remember it. Was there a provision in the contract between Mr. Hill and Ms. Carpenter-Smith for termination of the contract?
Yes, there was.
Okay. And what did that provision provide?
The provision, would you like me to read the term of agreement provision, or just that as it relates to the...
Just as it relates.
To the termination. This agreement may also be terminated by mutual agreement of the parties at any time with a 30-day written notice. Upon termination, owner shall pay to manager any fees, commissions, or expenses due manager under terms which are owing to manager.
Was there any bill presented in the documents of monies owed to the manager from Ms. Hill?
Not that were in the documents that were received by TREC.
And these are documents provided also by Mr. Hill?
That is correct.
So there was nothing provided that showed that he had to be paid anything on the termination of the contract, there was any money owing?
That is correct. None were given to...
And no provision providing that he was allowed to keep a third-party security deposit even after the agreement between the owner of the property and he was terminated?
No, there was not any agreement, and no.
I have nothing further at the moment, but I'd like to enter a copy of that complaint as my exhibit, next exhibit.
All right.
Number one.
Do you have copies to distribute to the board? Any objection, Mr. Jackson?
None at all.
All right. You can go ahead and distribute copies of that to the board, and I'll mark it as exhibit number 1. Thank you. Members of the board, why don't we take a few moments and let you look through that exhibit, and I think Ms. Maxwell testified to most of it, but before Mr. Jackson cross-examines a witness. All right, commission members, are we ready to move forward? All right, thank you. Cross-examination, Ms. Jackson?
Thank you, Your Honor. Ms. Maxwell, thank you. Your file, do you have a copy of an estoppel agreement that relieves Mr. Hill from his obligations under the lease with the tenant?
I'm sorry, what did you say?
Do you have an estoppel agreement of some sort that relieves him from his obligations under his lease with the tenant?
From the tenant?
Yes.
No, not in the lease, not in the
Okay.
file.
Do you have a lease amendment of any sort, substituting a different management company for Mr. Hill's company?
Not in my file, no, I do not.
Okay. Do you have anything in your file that shows that Mr. Hill's actions were anything other than him abiding by his obligations under the lease for handling the security deposit?
I couldn't make a legal interpretation of whether or not that's in any of the agreements.
Okay, but you do show that he put it in an escrow account?
It does appear that he put it in an escrow account.
Okay. You were just looking a minute ago at the management agreement. Can we turn back to that for just a second?
Okay.
Under the paragraph His term of agreement on the second page of that agreement?
Yes.
What paragraph is it, Mr. Jackson?
It says term of agreement, last paragraph on the second page.
All right. All right, thank you.
In the middle of that paragraph, the sentence starts with, "This agreement may also be terminated." Can you read me that sentence?
This agreement may also be terminated by mutual agreement of the parties at any time within a 30-day written notice.
Okay. Do you have any documents in your file that show a mutual termination of that contract signed by Mr. Hill?
No, we have 3 notices from Ms. Carpenter that she wanted to terminate it for poor service and change to a different company.
Okay. And that first request from her to get out of the contract, you said, was on October 31st of 2011?
10/31, yes, 2011.
Okay. And under the lease agreement that you were looking at, that Mr. Hill obtained that tenant on what date did it have the tenant?
Did the tenant moved in or what?
Yes.
The tenant moved in, I believe, on 9/16. Actually moved into it on 9/16.
Okay. On 9/16.
That's the date the tenant appeared to have actually
Okay.
moved in.
And then on 10/31, just to be clear, is when she wanted to, and she asked to be out of the contract on 10/31, that following month.
Yes, she did, and she asked for a mutual release of contract and security deposit.
Okay. But again, you don't have anything signed by Mr. Hill agreeing to terminate the contract?
No, we do not in our file have anything where he agreed to do it. He said that he wanted compensation to do it.
Thank you, Ms. Maxwell. I've got now.
All right, thank you, Ms. Jackson. All right, any members of the commission have questions for this witness? Ms. Grice?
Ms. Maxwell, I'm just confused slightly about the tenant. Is he still in the property? Did he leave shortly after moving in, or do you know the history of the tenant?
I do not know the history of the tenant. The security deposit was given back by Ms. Carpenter, the complainant, to the tenant in 2012. And I don't know whether that's the time that the tenant actually vacated the premises or whether that was there was some other action that prompted that. On 11/13/2012, Ms. Carpenter wrote a personal check for the return of the security deposit to the tenant in question.
Do you believe that the lease with the tenant was a year lease, or
It was a year lease. It says in the lease itself it was a year lease.
And do you have any indication that the tenant broke the terms of the lease?
We don't have it, and our file does not indicate that the tenant did.
Thank you.
All right, other questions? Yes, sir.
The $50 security deposit was an expense. It shouldn't have been recuperated, as far as it looks like to me, if they paid $50 for security to checking somebody out. But the commission, you also a while ago, wasn't any commission in it. There was 8% of the monthly rate. That's the second item on and it looked like he'd be entitled to that for the duration of the lease, whether she broke the lease or not. I don't know. That's a second paragraph on the, third paragraph on that same page.
The compensation manager.
Is that not payment? It was mentioned a while ago that he wasn't guaranteed any pay, but he is.
Our records indicate that the tenant had paid portion of the month of September, and October and November payments were made by
I'm
check.
talking about in the agreement for him to manage the property. The complainant said that she was going to pay him 8% of the rent. Is she just trying to say she stopped it and there's no mutual consent? I don't understand that.
Obviously I can't speak for the complainant, but the information that was supplied to our office she gave notice that she was going to terminate, and in fact, there's no evidence. It appears that the management was handled by another party after November.
Do we have that document? Do we have that agreement, the other party? Did anybody submit the other party's agreement?
No, I have not seen it.
So we just have the owner's word that somebody else was going to handle it, but we have no documentation?
We don't. All I have is the notice, that it was given that the security deposit.
She emailed him and said that somebody else is going to handle it.
And gave the name of the new management company.
But we don't have any documentation that the new management company even managed it.
No, we do not.
Okay.
Or at least I don't have it in the files that I have available.
Ms. Maxwell, let me ask you, and Ms. Ryan, you can help me. Are there any other documents other than Exhibit 1 in the file?
Oh, we've got.
Okay. Make sure we clarify. So whatever there is in Ms. Maxwell's file is what the board has under Exhibit 1. All right. All right. Other questions?
As Executive Secretary of the Tennessee Real Estate Commission, did he not have a fiduciary responsibility to that tenant to hold that money until that lease was up?
Well, I can't interpret the law, but there's a provision in the rule 1260-0209 that says funds in the escrow trustee account should be dispersed in a proper manner without unreasonable delay. They should be dispersed or interplayed within 21 calendar days from date of receipt of a written request for disbursement of the earnest money, and the licensee under 6213-403 has a duty to timely account for trust fund deposits, and 6213-312-5 provides the same thing.
All right. Other questions? Ms. McMullen?
I did. Thank you. You said that Tennessee Code Annotated 6213-403 addresses the duty to account for trust funds, and I want to be sure I have that section right. I think you said that it was B6.
It's 6. I'm sorry, it was 6.
Okay, there's no B. Okay, I just wanted to make sure.
I'm sorry, I think I did say B6, but
okay, I just want to make sure that it hadn't been amended subsequent to the book that I have. I'm looking at Rule 1260-2-.32, concerning civil penalties. And my book says that the violation for Section 6213.312B5 was deleted by 1988 amendment. Is there a subsequent version of the rule that provides for a civil penalty for violation of 6213.312B5?
The court, please, sorry, there is a need for clarification on that. And I will, if it's all right, I will let Ms. Kropp address it since she is the board attorney. And this was about changing the rules. Your book is not up to date.
I wanted to ask.
Previously, before we had passed out a set of the rules, when these rules were last revised, I believe there was a misnumbering of those, and it was corrected in the old version of the rules, which was handwritten in there. I think you all were given a copy of that beforehand. We had some rules that became effective as of March 3rd, 2013, which realigned, corrected in the revised version all of those civil penalties.
So what is the current civil penalty or maximum civil penalty for a violation of 6213.312B5?
The range is $300 to $1,000.
Maxwell, I want to make sure that I understand what you said earlier in response to Commissioner Grease's question. Is it your understanding that the tenant stayed in the property for the year and did not breach the lease, and so the tenant was entitled to the return of the security deposit, and that the complainant refunded the security deposit to the tenant out of her pocket? Is that correct?
That is what I understand. Yes, that's what I understand.
Okay.
All right. Any other questions from the commission? Yes, ma'am.
But we don't have checks that show that. It was just, but they both agreed to that? They said, both parties said that, yes, that's what she did? We don't have a copy of a check.
From
Or to the tenant.
Let me make sure that
I didn't see one in there. There may have been.
If I may, we don't have one either, but we do have a copy of a check where Mr. Hill refunded the earnest money back to Ms. Carpenter, but we do not have any evidence that she refunded that to the tenant, no, that I have in my
That's
file.
what I was curious about, the evidence that she had refunded it to the tenant.
Do you see any documentation of that, Ms. Maxwell?
that's what I was making sure that I didn't overlook that in the information that I have.
Your Honor, I can shorten it. The answer is no.
Okay, I just wanted to make sure I didn't have it in here.
Thank you.
Other questions from the commission? Mr. McMillan?
Are there any provisions of the Tennessee Uniform Residential Landlord-Tenant Act that apply here that would affect the handling of security deposits in this type of situation?
That act is administered by the Consumer Protection, Consumer Affairs, so I wouldn't know specifically whether there is or is not. It does require that it be held in a separate account and that you walk through the property at the end of the lease term with the tenant. Other than that, I couldn't answer that question.
Thank you.
All right. Any other questions from the commission? All right. Thank you. Redirect, Ms. Ryan.
Would you go to the property manager and tell me the date of that contract and when it was supposed to terminate?
The property management agreement ran from July the 6th of 2011, and it was to expire on July the 6th of 2012, unless it earlier expired by termination mutual agreement of the parties, or in the event the premises did not rent within a 90-day period of entering into the agreement, or a vacancy continued for a period of longer than 90 days.
So the lease agreement ended in July of 2012? I'm sorry.
Just for the management agreement?
I'm talking about the lease
Oh,
agreement.
I'm sorry, I thought you said the management
No, the lease
agreement. Lease agreement was entered into on the 16th day of September 2011, and it was to end on the 30th day of September 2012.
And the agreement between Mr. Hill and Ms. Smith had an expiration date of July of 2012.
That is correct.
And the money was paid back finally, not to the tenant, but to Ms. Smith in November of 2012.
That is correct.
That's months after the termination of the one agreement and several months after the lease agreement terminated. Is that right?
That's correct. It was paid back on 11/13 of 2012.
Now, Mr. Hill provided to us documents of his bank accounts. Is that right? Showing deposits and things on this property?
That is correct.
Do they expand beyond November of 2011?
No, they do not.
Is there any indication he was managing the property after November of 2011? Anything he provided?
No, there is not. The last deposit that he gave us is a deposit that was made November of 2011.
No indication that he was still managing the property in question? Any communications between him that he provided, he and the tenant?
No, there are not any communications that were provided after that time.
And he says on 11/13/2012, could you read that whole paragraph again? On his document, on his reply with the timeline?
11/13/2012, reached Mr. Jeffrey Gray after many attempts and was told he had moved.
And was told he had
moved.
And was told he had moved. Is that
Also
right?
discovered that he received a return of deposit from Tracy Carpenter
So
Smith.
he said the tenant himself received the deposit from Ms. Smith. Is that right?
That is correct. And Ron Harmon at Bob Parks Realty said Tracy Carpenter Smith had written a check for return of deposit.
And then on that day, is that when he finally sent the cashier's check?
On 11/13 of 2012, that same day, it appears, he went to Fifth Third and had the cashier's check made out to Ms. Smith.
Now, in the next paragraph, Mr. Hill says, I spent many hours outside the normal scope of manager advising her on the pairs and counting on management fee to compensate us for this and the many inspection trips we had made. In his timeline, besides what's here, does he provide anything that shows he did anything after November of 2011?
No, he did not.
I have nothing further.
All right, recross.
Please.
Hey, Ms. Maxwell, we just went over the property management agreement that was good until, on its face, till July of 2012. Do you have any evidence in your file that Mr. Hill was not managing the property during that time? Do you have anything at all?
That he was not managing it?
Yes. You were asked if you had evidence that he was managing it. We've got a contract. Do you have any evidence that he was not managing the property during that time?
No.
Other than the complainant's word that's not here? You don't have anything?
We don't have any evidence that he was managing it.
Okay. Well, no, I didn't ask you that. I asked you, do you have any evidence other than the contract that said he was manager, that he was not managing the property? Do you have
We don't have any paper that says he was or he was not. We don't have any paper that, or any deposits from his bank after.
How do you understand the property management agreement?
The term of the property management agreement is what I read in the.
Okay. So isn't that evidence that he was the property manager, as you've got a signed agreement with the owner?
That's what was signed originally, yes.
So again, do you have any evidence that he was not managing the property during the term of that agreement? Anything in your file?
We don't have anything in the file one way or the other.
The term of the lease was up at the end of September, you said, and you already went over what the conditions were for return of the security deposit.
That's correct.
So after the end of the lease, which was September 30th, the landlord, the property manager, Mr. Hill, was supposed to confirm that all of these things were true, and if all of those were met, he was to return the security deposit, which he did on November 13th. Is that correct?
You returned the amount of $1,050 to the Miss Carpenter, Miss Smith.
And he did that on the day that he confirmed that the tenant was out.
She paid the money, and she confirmed
she had returned it. But so do you have anything that shows that he did anything other than what Section 3 of the lease provided for?
I don't know whether he did those things or not. I mean, I don't have any evidence that he did any of those things.
So within 45 days after the end of the lease, which I guess 43 days after the end of the lease, he returned the security deposit. Is that correct?
He returned. He gave a check to Miss Smith for $1,050.
Security deposit.
I don't know I don't know whether that was the money that was actually given to him and held in escrow for the account of the tenant.
Okay, I think we have to assume for a minute that they only had one $1,050 check, and that was for security deposit. So, all right. One last question. Can you read that section provision again? You said about returning a proper request for return of. I'm sorry, I didn't have that.
From the rule?
Yes.
Do you want me to read the whole rule or just that part, number 7?
Please.
That's 1260-02-.09, number 7. Funds in escrow or trustee account shall be dispersed in a proper manner without unreasonable delay. Funds should be dispersed or interpled within 21 calendar days from the date of receipt of a written request for disbursement of earnest money.
Okay. Do you think, your understanding of that rule, that if Mr. Hill's obligated as a property manager under a lease where he's holding a security deposit, is it a proper way to do it if he gets an email from the owner saying, please transfer this security deposit with no request from the tenant, with no request from another management company, with no lease amendment? Is that a proper way to handle those funds? If he would have complied with that request, would that have been proper?
That would be a determination that would have to be made by the commission. I
Okay.
couldn't interpret
I'll
that
let
for
them
you.
ask that question then. Thank you very much.
One more follow-up, sorry.
Any questions at this point from the commission? Commissioner Reese?
In the exhibit, do we have a copy of the lease?
It's in Exhibit 1, right here.
Okay. I have just a second to look at that. I just missed it.
I have one more question while he's looking it over.
All right, go
What
ahead.
was the date that the tenant moved out?
I don't have the date that the tenant
Is it anywhere?
moved out.
Do we know it anywhere?
The information I have is that the lease ended, the end date of the lease was September 30th of 2012.
I'm fine, thank you.
Questions? All right.
One
Ms.
follow-up.
Ryan.
On 11, if you look again at what he provided to us, please, his statement of activities, look again at 11/13/2012. And it says what?
Reached Mr. Jeffrey Gray after many attempts and was told he had moved.
Now, when did the lease expire?
The lease, according to the lease terms, expired September the 30th of 2012.
That indicate at all that somehow Mr. Hill had been A, in communication with him, or B, had been over there to look, or C, even know where the tenant had moved out?
It would not indicate that.
So he didn't know, at least according to him.
That would appear to be that correct.
I have nothing further.
Anything else, Ms. Jackson?
Yes, sir.
All right, anything else from the commission? All right, thank you. Yes,
Judge, if we could, let's take a 10-minute break.
certainly. We'll take a 10-minute break, and Ms. Maxwell, if you'll step back down with your counsel. And
But before we go, may I ask that, Your Honor, my next witness would be Tracy Smith. We contacted her by telephone. She talked to me 2 days ago, but I had Ms. Kropp call her. She read the subpoena as being April 7th. However, she is available by telephone. If we can please allow her to testify by telephone. I realize that's not the optimum, but she is listed as a witness on my witness list. I did talk to her. I don't know why she miscommunicated, but she is available and she's standing by.
all right, let's take a 10-minute break, and we'll take that issue up.
Thank you, Your Honor. It's the one that's in charge. She's like that referee that's got that red hat on the football field.
When I was growing up, they called it the man with the butter. So,
My next one.
all right, let's go back on the record then. Let's see, Miss Ryan, you want to just before we broke, you said there was a problem. You had some contact with your witness.
Yes, and let me explain. I had subpoenaed Ms. Carpenter-Smith, and I spoke to her 2 days ago, and she was absolutely preparing to testify. I should have read her the subpoena because when we called her, she read it as April 7th instead of March 7th. This is what Ms. Kropp said. And that she was in Chattanooga today, but she was available by telephone to testify. And I asked, and I'm asking, that she be allowed to testify by telephone. I'm asking you as the commission. I'm sure the respondent has their own point of view, and I've asked the judge. And that's where we are right now.
Well, we'll take that up. Let me tell the commission, under the Administrative Procedures Act, Section 4-5-312, C, it requires the agreement of the parties under the current act, and this is an issue that arises for us. We've actually sought to make some attempts, or made some attempts to get it modified, but we do not have an agreement, Mr. Jackson, for this witness to testify by phone.
If I may,
Well, that's a simple yes or no.
No, I don't agree.
Okay. So there's no authority under the Administrative Procedures Act for me or the commission to allow the phone testimony without that agreement. So,
I have another motion then, please.
all right, what's your next motion?
Then I would ask that this matter be continued to the next available date, which we have is in November, because I think Ms. Smith's testimony is important for some of the questions that were asked and issues that we have to address today.
And let me clarify, Miss Carpenter-Smith?
Carpenter-Smith.
Okay. She was subpoenaed. She was actually served.
She was subpoenaed and actually served, and I spoke to her because she called me once receiving the subpoena.
Okay. Have you had contact with her prior? You said you spoke to her today.
We spoke today, and I spoke to her a couple days ago.
Okay. So when you spoke to her a couple of days ago, she was unaware that the hearing was 2 or 3 days later?
Yes, apparently. And
All
I
right.
did not clarify that with her because I thought she had the subpoena there. She misread it for whatever reason.
Okay, so we know she actually had it in hand. All right, Ms. Jackson, that's the motion before the committee. Members of the commission, under the rules, either the administrative law judge or the commission can grant a continuance, and since we're in the middle of this hearing, the technical term from me is I'm punting it to you. So the commission you can vote and do what you want to on this one. Ms. Jackson, what's your position on continuing the matter to the November hearing?
Well, we're all here.
Are you using your microphone there?
It's on.
You just about have to get on top of it, so go ahead.
Is that okay?
Yeah, I can hear you then.
I think it just begs the question that if she was on the phone with her a couple of days ago, and we're all here, and I'm paying somebody to cover 3 hearings for me across town, I think it would prejudice Mr. Hill to wait till November to get this thing resolved. We're ready to do it. We're here, and I think we've got everything we need for the commission to make a decision. And so I would not be okay with continuing it until November. I don't know. I can't see a reason why we can't get this done today.
Let me address one other thing. I did not know Mr. Hill had an attorney till I walked in this morning. I have not been provided with that information or with any information about how he planned to handle this case, any documents, any exhibits, any witnesses. So I would suggest that if there is prejudice here, it is on both sides. And I would further suggest that the testimony of Ms. Smith is important to this hearing. And I'm asking the Commission to seriously consider that, because there are questions that only she can answer. And I apologize that she's not here. My subpoena power is limited. She was a willing witness, which we don't often get. I'm sorry that she misread it for whatever reason. But I am asking that if I'm not allowed to have her testify by telephone to answer some of the questions you have, that we continue this until such time you can make a full and proper determination of the issues.
All right. Anything else, Ms. Jackson?
No, other than I don't have any exhibits or documents or witnesses. I'm just here to go through what was already in the record. So, but if I could just for a second argue an alternative, I would request.
Let's let the board pass on this issue before we take up anything else.
Okay.
All right. So, Mr. Stevenson, I'll turn the matter back over to you to consider Ms. Ryan's motion to continue the matter at this point.
This time, as chairman, I'm opening the floor open to discussion about Ms. Ryan's motion to continue this matter until November.
Yes,
I hear you say.
I have hearings scheduled with other people prior to then.
Mr. Chairman,
Commissioner
may I
Grease.
ask the judge a question?
Yes, sir.
Yes, you may.
Sorry.
So, my own personal position would be I'd prefer to hear from Mr. Hill before I try to make a decision on the continuance. I may get all the information I need and not need a continuance. Is that appropriate, or do we have to handle it at this point?
Well, the motion's on the floor at this point, and it doesn't. I don't know that there is any particular order. This is kind of a novel issue that arises. I don't know if the board could, or the commission could, and I apologize, commission could defer the motion until further proof is presented. Of course, I would point out that at that point we might be continuing the matter solely for that witness's testimony. With their, I don't know that it's going to get better or worse. I can't tell you that, but I think you need to consider that.
Mr. Chairman,
Commissioner McMullen.
I feel like we have heard a lot of testimony already from Ms. Maxwell, and we have the entire complaint that was provided to us in writing, including a pretty lengthy statement from the complainant, and has a lot of documents attached to it. I feel like we have a lot of information in front of us already, and we're really dealing with what looks to me like a relatively narrow question, which is, did the licensee fail to account for or remit this money within a reasonable time, money belonging to somebody else? And so I'm not sure how beneficial this additional testimony is really going to be, and I am with Commissioner Grease in thinking that I would like to hear the licensee's testimony, and at that point perhaps we might be willing to entertain this motion again. But for now, I'm comfortable going forward with what I've heard and has come into evidence already without any objection from Ms. Maxwell.
I agree.
Chairman,
Commissioner Northern.
I concur with Commissioner McMullen. To me, I'm not going to say it's cut and dry, but there are only two questions: whether or not the funds were properly dealt with, and whether or not there was a management agreement in place at the time. And I think the documentation that we got here speaks clearly as to both of those issues. I will say that if there's additional testimony from the respondent that raises cause for the complainant to be present, I would consider it at that time. But at this point, I don't see the need for a continuance.
Your Honor, I take from the comments you made a second ago that we need to resolve and take action on the motion that Ms. Ryan has put before us before we can even continue.
No,
we don't.
That was not my point. My point is that I think you need to consider whether you want to hear this and then maybe pick the witness up later in November, or you can rule on it this time. My only point to Commissioner Grease was that you want to consider whether or not it's going to get better or worse under those scenarios. But you can certainly vote to delay the motion until later in the hearing today. The motion to continue.
I'll put that motion on the floor, Mr. Chairman. We delayed consideration of the request of the state for continuance.
We have a motion on the floor by Commissioner Grease that we delay the motion that was made by the state and continue, and we have a second by Commissioner DeShara. Any discussion on the motion? Hearing
What
none.
would be the, at the end of the proof, would we just bring the motion back up at that point? Is that the plan? Yes, okay.
Yes.
Okay.
Hearing no, any further discussion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries. Proceed, Your Honor.
So the ruling is that they'll take Ms. Ryan's motion under advisement until they hear the proof, and then they'll rule on that issue. All right. Next order proof, Ms. Ryan.
Just briefly, I would like to call. Do you want to say anything about? No, I'm going to call Mr. Gaius-Hill
All right,
and
Mr.
have
Hill.
him please qualify as an adverse witness.
All right. Mr. Hill, if you'll take a stand over there, and I'll place you under oath. So raise your right hand, sir. Do you solemnly swear or affirm to tell the truth and nothing but the truth, so help you God?
Yes.
All right, and state your full name on the record for us.
Gaius Hill.
All right, thank you, Mr. Hill.
Mr. Hill, the property management agreement for the property at the Calais Circle in Antioch, that was property owned by Ms. Carpenter?
Yes, it is.
Okay. And you had a lease agreement with Mr. Jeffrey Gray, is that correct?
That is correct.
And the security deposit was $1,050.
Yes, it was.
And you received that money on 9/3/11, is that right?
I believe that's correct, yes.
And you deposit the same day?
Yes.
Okay. Now, Ms. Carpenter sent you an email on 10/31 wanting you to be relieved as the property manager, didn't she?
Yes, she did.
And in your response to the complaint, you said that there were issues, and one of her complaints was she didn't get rent paid on time. Isn't that right? Isn't that what she said?
That according to her, yes.
Okay. Well, your documents show that you received an October rent on 11/5/2011. Is that right?
Yes.
And then 10/11, you did to pay a check to Ms. Carpenter. Is that correct?
Yes.
And then you received a rent check for November on November 1st of 2011. Is that right? That's what you said here. Is that right?
I think that's correct. I'm not sure the exact date, but that's very close.
And then on 11/11/2011, Ms. Carpenter called you, and you said you informed her that I was in my vehicle and office hours are closed, but I thought the check had been cut and mailed. Is that right?
Yes, that is correct. That
And
was
then-
Friday afternoon about 6 o'clock.
Right. And then on the 14th of November, you discovered the check had not been sent out, and you called her, and she once again came to pick up the check. Is that right?
Yes, she did not want it mailed. She said she had to have it that day and
Okay.
wanted to come and pick it up.
When were rents supposed to be paid to her, rent monies, in your property management agreement?
The property management agreement says that we will pay the rent to her on or before the 10th of the month, providing that we have received rents from the tenant.
And it looks like, at least in that case, you received it on the 1st, but it didn't get paid to her till the 14th. And that was one of her complaints, wasn't it?
It appears that way, yes.
Okay. And in fact, she didn't actually get it to the 15th when she came to pick it up in person of November. That's what you have here. Is that right?
Would you repeat the question, please?
She picked it up on the 15th. So even though it was supposed to be on the 10th, you didn't give it to her to the 15th. Is that right?
Well, I think she picked it up on the 14th, actually, but
you said
14th or 15th, one or the other, yes.
You said the 15th. Okay. And then in your documents that you provided us, you have nothing between 11/15/2011 and 11/13/2012. Were you managing the property then?
I was not actively managing the property at that point. That is correct.
You were not actively managing that property. Okay. So you had no idea whether Mr. Gray was in the property or not, did you?
Well, yes, I did up until about May of that year, because due to my responsibilities to the tenant, having a lease in effect and in force with that tenant, I kept up a correspondence by phone with Mr. Gray during this entire time until it was apparent that he was okay. He was happy and everything was good.
Where's that in here when you gave that to us? Where's that information?
Excuse me?
Where's the information that you gave to us? You don't have anything from November of 11 till November of 12.
That's a concise timeline of actual events happening. That does not record all the phone calls.
Okay.
Probably at least somewhere between 50 and 100 phone calls to Mr. Gray are not on that list.
Okay, but then said from May, only until May. So from May until you called him again in November, no contact.
That is exactly correct.
And you weren't over at the property. And you weren't managing the property.
I drove by the property once or twice, but I couldn't tell you the dates. I was not actively handling accounts or managing that property.
And in fact, you reached him, you said, after many attempts, and found out he had moved.
Yes, that was...
So you didn't even know that?
I did not keep up contact after about May with him, and I did not know that he had moved or renewed his, or entered into a lease with someone else.
So even though you might have had a dispute with the property owner about your contract agreement, which you could have sued in court, instead, you didn't do anything, and you kept the security deposit. Is that right?
Would you repeat that again? I want to make
said,
sure I'm answering your question.
Even though you could have done something about your dispute with Miss Carpenter-Smith over what monies you said you were owed,
Yes.
instead you just kept the security deposit in hostage. Is that
No,
right?
I did do something.
Did you keep the security deposit?
The security deposit was kept as it was the tenant's money and the lease was in effect, yes.
That's not what you said, though, in some of your emails. When she asked
I'm sorry?
you for, that's not what you said in some of your emails.
What did I say in my email that's
I will be happy
different
to read
that?
them to you.
Thank you.
Please release, this is it. Please release the security deposit. This is on November 3rd. In check form made out to Parks Property Management. And your response says, our contact calls for a 30-day notice upon mutual agreement. To date, we have a monetary loss compared to services rendered for fees received. We found you a good, solid tenant who pays and pays in a timely manner. Our expectation is to receive our fee of $100 a month for an additional 10 months. What are you proposing as a reasonable termination fee? When did you address this whole issue of the security deposit there?
We did not address the issue of the security deposit at that point.
And did you ever address the issue of the security deposit?
No, we never had a request to address it except by email from Ms. Carpenter. No one ever sent us anything that said, please release this, the lease has been amended, or an estoppel.
The owner of the property
But
said,
it wasn't her money.
Let me ask you this question, sir.
Okay, sorry.
The owner of the property said, send this to this new property management company. Why didn't you just do that? Or why didn't you contact Gaius Hill? I mean, why didn't you contact the tenant and say, that's what I'm going to do? Why didn't you do that?
Well, let's ask you one question at a time.
Pardon.
So,
Why did you not, first one, why did you not release the new property management company when asked?
I didn't have I cannot release by an email from an owner money. I did not feel like I could release money that belonged to someone else to a third party with no documentation, nothing.
So why didn't you call the tenant?
Oh, I did call the tenant.
And what did the tenant tell you?
The tenant told me that Ms. Carpenter Smith, well, she had asked him to cover for her on some of her stories that she had made up.
I'm going to object to that. I'm asking what he told you about who was managing the property.
That is what he told me.
That who was managing the property?
No, he didn't say. He didn't appear to have a clue who was managing the property.
Did you collect the rent from him during this?
No, ma'am, not after November.
Wasn't he supposed to give you the rent money in the contract?
Yes.
So who was he paying the rent to? You don't know.
That's correct.
But you still kept his security deposit.
Yes, ma'am.
The lease terminated in September, right?
Yes, ma'am.
And you didn't know that he had left already. You have no idea when he left.
I did not know at that time that he had left.
Do you know when he left the property?
After I did reach him in the early month, sometime during November there, probably about the 10th or 12th.
13th.
13th, okay.
Ms. Ryan, let him finish his answer before you talk over it. Thank you.
I've forgotten the question now, I'm sorry.
Let's ask him another question.
I'll be happy to. The security deposit, okay? When did you find out he moved out?
I found out he moved out for sure on 11/13.
And what was the date he moved out?
I was told he moved out at the termination of his lease, which would have been the end of September.
But you did not know that beforehand?
I did not know that.
When
No,
was the termination of your agreement with Ms. Carpenter Smith? What was the date of that?
On our agreement, it stated that it was from July to July.
Of 2012.
Yes.
So the agreement you had with the owner of the property was already, if no other way, was already void at that point. Is that right?
I think that's a gray area when you have a tenant in place, but I don't know why it wouldn't be.
Why it wouldn't be what?
Why it would not be terminated.
And in fact, someone else was managing the property the whole time after November.
I don't know.
Well, you weren't managing it.
I agree with you.
Okay. And you weren't doing anything to make sure that the only thing you were doing was holding money hostage.
I disagree with
Well, then
that.
how come every time you were asked for the escrow money to be released to new property management, you kept on talking about money owed to you?
I wanted to impress upon her that I don't think that one person can send an email and unilaterally terminate a written, signed real estate contract in the state of Tennessee.
Well, I understand that, but you still, what right did you have to keep the security deposit when another management company is managing
I wasn't keeping it for myself. I was keeping it on behalf of the tenant. I get nothing for keeping this money.
Why didn't you know? Why didn't you find out? Why didn't you find out who the management company was, if there was one in place, and release it to them?
I wanted to settle this amount with her. I offered to settle it with her for $250 as payment for the months that we expected to receive money, and she more or less threatened me that going to Better Business Bureau, Consumer Affairs, and Tennessee Real Estate Commission. All three of those were done. I've spent many dollars, not counting today, because I'm trying to do the right thing here.
And the right thing is holding money, even though there's another property management company in place, and as you just said, your issue is being paid to you, and not this third party's money that you have no interest in.
Well, there's a responsibility as long as the lease is with my company, which I had no indication that it's not. I have a responsibility to this tenant to protect his money.
But you...
What do you do?
You knew that someone else was managing it, sir, because you weren't being paid the rents. But you didn't bother, as part of your responsibility, did you, to find out for sure and make sure the security deposit was in the right place for the person at time, did you?
I was waiting for a request to come to do that, and I never received any request of any kind from anybody.
Why didn't you
other than this email?
Why didn't you do it yourself, sir? If you were so worried about that tenant's money, why didn't you take the step to find out exactly what was going on?
After the hours we'd spent, I was probably trying to make money and keep my company open. Ma'am, I don't have a good answer for that.
And in fact, the money had to be paid out of Miss Carpenter Smith's pocket herself. Isn't that right?
I don't know what had to be done. Once I found out, immediately as I found out that she had paid it, immediately went to the bank, to the escrow account where the money had resided the entire time, and cut the check, which we have a copy of in the evidence, for Ms. Smith.
Yes, you did. After you found out that she paid it. Is that right?
Yes.
Okay. Now, this complaint was filed in July, so you knew this was an issue last July, didn't you?
Yes, I did.
And you didn't address it then, did you? Did you
Yes.
go and did you
Yes,
put the
I
money?
did.
Did you?
I did address it.
Did you put the security deposit with the person who was managing the
No.
property? You did not address it then?
No, I did address it.
You did not address the issue of the security
Yes, I
deposit?
did.
Listen to me carefully.
I am listening.
Being paid to the property company who was managing the property at the time.
I did not pay the escrow money to anyone at that time.
Yes, and you also then didn't bother to find out from the tenant if indeed what was going on. You didn't do that either. You weren't collecting rents. You don't know what was going on. You didn't do anything. You just kept the money in the bank and fought with her about being paid.
No, we tried to contact the tenant at that
You
point.
said you didn't try to contact the tenant until November, and you had no contact with him from May to November. That's what you testified earlier.
I've tried to say that I had no contact with him after May until November. That's what I was trying to say.
Well, that's what
I'm
I
sorry if that's not what I said.
Well, then in July, when you got this complaint, did you contact the tenant?
We tried to call the tenant. We did not get through to him. He did not return the call at that time.
And in fact, you didn't even bother to release the money until after a conversation with Miss Julie Kropp in November. Isn't that right? That was November 13th, and you talked with her earlier than that.
Yes, Miss Kropp had called me, and I said, Miss Kropp, what would you do? And she said, I cannot advise you. I said, what do you do in this case? Is that, I believe is what I said. Some words to that effect.
Call an attorney?
Yes.
And what did the attorney advise you to do?
Well, the same thing he advised me to do when I contacted him back in July.
That's not an appropriate question.
Well, he just suggested that he
Well,
called
I
this attorney and asked
Yes.
for advice, so I was just following up on
Yes,
this question.
we've been under advice.
The
Okay.
advice the attorney gave him.
I understand. But then you finally did release that money, didn't you?
Yes, ma'am.
Finally. I have nothing further at the moment.
All right, questions, Mr. Jackson? This, Ryan, do you have other testimony? Okay, so this is all your proof. Do you want to just, you going to present proof other than Mr. Hill? No. Okay, so you want to address it all now? Sure. Let's go ahead and take up all of his testimony.
Yes. How long have you been a real estate agent? Since 1978. Have you ever been in here before the commission?
I've not been here before. I do appreciate that we're here for the protection of the public, and I appreciate the time spent here. I've not personally been here.
All right. Let's go back through this just for a minute here. I think we've got most of what we need. But just for everybody's benefit, let's just kind of have a recap. In July, you signed a management contract with Ms. Carpenter. Is that correct?
Yes,
And she asked you to find a tenant?
absolutely.
Okay. And you were able to do that?
Found a great tenant.
So the tenant was, you procured the tenant?
Yes,
That tenant moved into the property, started the lease in September 16th, is that correct?
yes.
Now, when did, I think it's already been mentioned, but just to be clear, Ms. Carpenter emailed you and wanted out of that contract. When was that?
I believe it was October 31st.
Okay, so, 43 days after you signed the contract with her?
After we signed the lease.
The lease? After
Yes.
After you got her, 43 days after you procured a tenant for her property, which she asked you to do,
Yes,
she wanted out of the contract.
yes.
Let me ask you a simple question. If every property management customer you have waited until you found them a tenant and then wanted out of their lease, how long would you be in business?
Fortunately, most of my people are extremely loyal, but I would obviously be out of business immediately.
Did you ever receive anything other than this email from Ms. Carpenter that relieved you of your obligations under this lease with the tenant?
Nothing,
No estoppel agreement
nothing,
signed by him, no lease amendments,
nothing,
no request for trust fund transfer from
No.
another management company?
no.
Do you know for a fact that she wasn't managing this property herself?
I found out November 13th from Ron Harmon that he had been managing the property.
But
November
he
13th,
never asked you
2012.
Okay. He never asked you for the earnest money or the security deposit before that time?
No.
All right, Gase, you're a smart guy. What would have happened? Let's just ask a hypothetical. If you would have done what she asked you to do, your understanding of the rules, what would have happened to you?
I think that calls for speculation. Unless he can answer, knows what the commission has said and done in the past, he can't answer that question.
I'll overrule the objection. I think his interpretation of the rules is certainly relevant, and his experience allows him to do that.
If I had honored her request and sent the money over to Bob Parks Realty at that time, I would have been in serious violation of my responsibilities as a real estate agent.
Did you ever do anything to jeopardize this tenant's security deposit?
Nothing.
Did it ever leave your escrow account?
It never left the escrow
You never
account.
used it for personal
Never
purposes?
used for anything. It sat in Fifth Third Bank.
You didn't violate this lease with that tenant at any point
Not.
in regards to the security deposit?
No.
Okay. Now, the lease agreement ended on September 30th, and nobody seems to know for sure when the tenant left, but let's just assume, if it's okay, that he left when he was supposed to, on September 30th, okay? Now, the lease agreement, which is already in evidence, says that after that date, okay, so now we're talking, I don't know what day of the week that was, but let's assume October 1st. Under the lease, your obligations were to do a long list of things, okay? To make sure that they've moved out, that there's no damages. We've already gone through what those things are.
Yes.
Were you doing that during that time, trying to figure out?
I was trying to contact the tenant by phone to find out if he had renewed his lease
What if it's
or
up-
if I needed to do anything else for his deposit.
One of the obligations or one of the requirements under that security deposit section is that he's supposed to give you a forwarding address. Did he do that?
No.
So did you have any way to contact him after the termination of the lease?
Only a cell phone number that was not answered repeatedly.
During that time, you were trying to determine if he was out.
Yes.
please.
All right. So you were trying to fulfill your obligations under the lease after that.
So I think it was the same question.
What were you doing after September 30th?
Trying to find out what to do with the escrow deposit and do it properly.
And you were told that, I think was mentioned earlier, that Ms. Carpenter had refunded the security deposit to the tenant.
I was told that on November 13th, 2012, whereupon within 2 hours of receiving that news, I was at the bank getting a cashier's check made out to Ms. Tracy Carpenter Smith, which was mailed to her that day.
Your opinion, is that 2-hour time frame a reasonable amount of time after you discovered that the obligations under the lease were done?
I really don't know what else I could do under all these circumstances other than what we did.
During that time that you were still managing the property and still acting under the lease agreement, did you get paid by Ms. Carpenter for what you were doing?
After the relevance of that, that's not the issue here today at all. Whether he was paid or not is not the issue.
I think they made
I'll
that the
overrule
issue,
the
didn't they?
objection. The issue's been raised by the department, and I think it's before the commission at this point for consideration.
Would you repeat the question, please?
Were you being paid by Ms. Carpenter as she was receiving rents? That
We were paid through a deduction of our portion of the management fee from the rent supplied by the tenant. So yes, it was. We were being paid by Ms. Carpenter in that way.
when did that stop?
I believe November was the last month that was November of 2011. We received 1 or 2 months management fees from her.
Your management contract was through July, but you did not get paid your part of your commission on those rents through that time.
No, we did not.
Does the lease agreement have, and this is your lease agreement, so you're familiar with it, does it say anything in there about you turning over any security deposit if the owner tries to cancel your management contract?
No.
Does one have anything to do with the other as far as that goes?
I couldn't figure it out if it did.
One last question. Your understanding of your lease agreement and your obligations on your lease agreement, is it your opinion that you've fulfilled your obligations under that lease till the end when you return the security deposit?
Yes.
Nothing further, Your Honor.
Thank you, Mr. Chairman. All right, any members of the commission have questions for Mr. Hill? All right, ma'am.
I've got a few questions for you, Mr. Hill. You did, in fact, receive the first month's rent and then the 8% from the rental for the months that you did, in fact, manage the property, correct?
Yes, ma'am.
Okay, in the Brokers Act, it says that if you receive request in writing for the security deposits, that is notification to you to release the money. You said that you didn't know what to do with it. Did you ever attempt to call the Real Estate Commission and ask them?
I do not recall. I did have some conversation. I tried to call a hotline attorney at that time, and I believe he told me to call the Real Estate Commission. I believe that I did try to call at that time, but I don't recall who I spoke to or the result of that. It was not conclusive to me at that time.
So you don't recall whether you spoke to Ms. Kropp or?
I did not speak to Ms. Kropp. I would remember that name. I did not, and I don't believe I spoke with Ms. Ryan. I'm not sure that I actually spoke with anybody. I do remember that morning trying to make the calls, first of all to the hotline, and then I believe that I called to the commission, but I'm not 100% sure of that. Let's just say I did not call the commission because I can't remember for sure. I think I left a message, but I couldn't swear to that.
You do acknowledge that you received in writing from Ms. Carpenter Smith a request for the security deposit to be sent to Parks Realty and also to terminate her lease?
And by email, yes, I did.
Okay.
Absolutely.
Thank you.
Other questions?
Commissioner Northern.
Mr. Hill, by contract, when did your management agreement expire?
By contract, it expired in July. We've since amended that to go through the end of leases to keep that conflict from happening again, but at that time, it strictly said for 1 year, from July to July.
It has an automatic renewal clause, but it doesn't specify what triggers that. Can you help me understand?
If the tenant,
That was in effect at the time?
if the same tenant were to stay in, it was the understanding that it would automatically renew, which happens, as you know, quite frequently.
There is no reference to cancellation other than the term clause in your contract. What do you consider to be reasonable cancellation?
If they will ask me nicely,
If they would ask you nicely?
if they would just be reasonable and ask me and just say, I'd like to cancel my contract, and if they have a reasonable reason for canceling that contract, we cancel their contracts. If there's anything reasonable at all that we feel like is reasonable, in our opinion, we would cancel the contract, even though it is a loss of money to us.
The email that was sent requested a termination. And
Yes,
I
sir.
understand from your testimony that you're saying it wasn't mutually agreed upon. Did you provide management services from that point forward to the end of the contract?
There it goes.
Oh, we did not handle any funds and handle any management activities that way. We did continue to check with the tenant occasionally to see. I just wanted to make sure that everything was in order as far as he was concerned, that he was taken care of.
With regards to compensation per your management agreement, you're to be paid from monies collected. Is that correct?
We are to be paid 8% of the rental amount per month. I don't know what the word is exactly.
All rents collected per month.
Okay, then that is the agreement. Yes, sir.
So are you saying that you collected any rents beyond the requested termination?
Sir, we personally did not collect, as a company or personally, any rents beyond that date.
In accordance with your management agreement, would you be in a position of being compensated for that period of time that you no longer managed or collected rents?
I'm not sure, according to the wording on that management agreement, whether we would or not. It was certainly the understanding with them that we would be paid for that time. This is the first I've heard of that I've considered that particular language, sir. And according to what you're telling me now, maybe not.
Under the terms of your management agreement, you were to be compensated for other expenses that you advanced. Were there any other expenses that you would do other than management fee?
Not under the management agreement terms, no, sir.
Your management agreement expired in July of 2012. You ceased activity in November of 2011, and the tenant vacated. When did the tenant vacate?
I think everybody stipulated September 30th, 2012.
So your obligation to the tenant expired upon vacating?
Yes, sir, at the end of the lease. Yes, sir.
But you failed to refund the money or transfer it or put it in the court's possession for an additional 3 months?
No, sir. Well, that may be the end result of it. We were certainly trying to find and make proper disposition during that time. That would be October. That would be about 43 days of trying to make that happen. October, 43, 44 days.
One last question. Your purpose for holding the security deposit was because of an obligation you felt to the tenant?
Absolutely.
And when the tenant vacated, you did not do any kind of move-out inspection or anything in accordance with landlord-tenant law?
No, sir. We were trying to find out if he was still living there or not, or if he had moved. We were not given a forwarding address or any information about that. We had to find out on our own.
So you made an assumption that there were no damages or anything that should have been deducted from the deposit?
At that point, Ms. Carpenter-Smith had already made that assumption for us by returning the entire deposit to him. Since she was out of pocket that amount, it was only fair that we return the entire deposit to her.
Thank you, sir.
All right. Other question? Yes, ma'am.
Since you're on that, did the other management company or Ms. Smith, either one, notify you that the tenant had moved and the security deposit should be returned to her, or the tenant said the security deposit should be returned to me? Was there any notification of anybody give you any kind of notification, writing, telephone calls, anything saying you've got this security deposit, it belongs to me?
None at all.
Okay. So you had to find that out for yourself, and it
Yes.
was just
Yes.
by hearsay? Okay.
Yes.
Other question? Mr. Price?
Your Honor, did you ever consider the tenant in default on the lease because he quit paying you or your company rent?
No, he told me himself that he was paying the rent, and I had nothing to indicate otherwise. Other than his first check, which bounced, and so after that, for the next 2 months, we did verify funds before we released the tenants. The owner's check, we had to verify that his checks were good after that, but it turned out just a mistake on his part, written on the wrong account, and after that, he was good to go. He was golden.
You only collected maybe 2 checks from him,
2 checks, yes, sir.
so he was golden on one of them, is that right?
Well, the first one was actually 2 checks other than a prorated amount. The first prorated amount is the one that bounced back to us. The next 2 were good.
I'm trying to get inside your head as far as what you believe at the time you find out he's writing checks to somebody else. Do you believe you're done?
I've never run into this situation before where we had a lease with somebody and no one ever did an estoppel. There's always an agreement accompanying a transfer of a lease with our company to the tenant. I've never had that. I've never seen that.
And no other management company asked you to assign the lease to them?
No.
And the tenant never asked you to assign the lease to anyone?
No, sir.
And frankly, the landlord, the owner, didn't ask you to assign the lease, did she?
No, did not mention it.
Okay, thank you, sir.
Other questions?
I have a follow-up question to Commissioner Grease. When she actually asked you to terminate the lease,
Yes, ma'am.
did you at that point make any attempts to send her a release or a transfer to another company?
No, ma'am.
So I'm kind of like Mr. Commissioner Grease. I'm trying to get inside your head. What was your thinking on not agreeing to release it?
Thinking was that she was very threatening to me. If you don't do this, I'm going to drag your name through the mud. You're going to go to Better Business Bureau.
I'm going to object
Tennessee
to the
Affairs.
hearsay
I'm
testimony
sorry.
of somebody that's not here to testify
Sorry.
on those kind of remarks.
Well, I'm going to overrule the objection. I don't think he's offering it for the truth of the matter asserted. He's offering it to show his response to those statements. Whether she intended or was going to do that or not is irrelevant, so I don't think it's hearsay. Go ahead, Ms. with your testimony.
I tried to explain to her very nicely in my emails that I didn't feel like she could unilaterally terminate a written, signed Tennessee real estate contract. She kept trying to do that by email. In my opinion, since that's what we're talking about here, what was in my mind, we did more to help this woman than anybody we've ever dealt with. And we've got 78 owners that we deal with. I personally made 12 trips to this house before it was rented out, trying to help coach on repairs and get this leased out. I did feel like that we were still going to make some of that up in the preceding months after this. Yes, I did. And I did not want to terminate this contract to someone who was going to make me terminate it. I just didn't want to do that at that time and take that loss.
Well, if she was so, I guess what I don't understand is if she was so threatening and so hard to get along with, why would you want to continue that relationship?
That happened at the end. She had been very happy with us up until these emails started, it seemed. Thank you for getting my property leased so quickly. Thank you for getting a good tenant.
But when she asked you to release it at that point,
everything changed.
I've got a question. Did she get a better deal than 8% a month? Because she signed an agreement with you for 12 months.
Yes, sir.
And you find her a tenant.
Yes, sir.
Tenant writes you a check for a prorated part of 1 month and then 2 more months rent checks.
Yes, sir.
And then all of a sudden, he's writing his checks to, I think, Bob Parks. I think that's what it shows in here.
Yes,
I just, out of curiosity, just all of a sudden, why did she just say, whoops, I am not going to fool with you anymore. I want Bob Parks to handle my house. And I don't know if he does it cheaper. I don't have a clue. I don't do property management.
I don't know. The first indication I got was a phone call that chewed me out for about 15 minutes one Friday afternoon.
Can you remember what month, what year that was?
That was in November of 2011.
Okay.
Ms. Carpenter-Smith's not here, but the way I remember that is she was extremely mad that I had moved the tenant in the middle of the month, although she was begging me to lease it quickly, because she had to drive to Smyrna to change for a wedding rehearsal, she said, had to drive an additional 8 miles instead of being able to change at her own house. And I really didn't know how to respond to that.
Okay, thank you, sir.
Other questions from the commission? Direct.
So your contract said it'll only be terminated by mutual agreement, right?
That is correct.
And she gave you written notice in November, and you quit acting in November. Is that right? You quit doing anything. You quit collecting rents. You just said you did.
I believe we've. Should I try to answer that again? I'll
Did
be
you
happy
collect
to.
rent after November?
We did not collect rent after November.
Isn't that one of the provisions of your contract? In fact, one of the main provisions of the contract? In fact, let me read it to you.
Yeah,
So
that is a provision.
Oh, it is, okay. So, but you didn't collect rent after that November, right?
No, but we were ready, willing, and able to.
But you didn't do it. So
I thought
how was
ready,
that-
willing, and able was a tenet of our business. I'm
then-
sorry.
If that was one of your main responsibilities, how was that not a mutual agreement at that point, that the contract was no longer valid if you weren't doing the work under the terms of the contract?
You're asking me what now?
I said, she told you she wanted to terminate, and after November 11th, you did not collect the rent, right? And you didn't maintain the property pursuant to the contract either, did you? Did you do that?
First question about did we collect the rents?
Did you?
No, we didn't. We never received another check, but this was nothing to do with our determination.
After November 11th, did you decorate, maintain, and repair the property?
No, we did not.
So you didn't do any of the terms of the contract anyway. So why was that not a mutual agreement at that point?
Because we had no choice in the matter to make it mutual.
Okay. And I've got another question. On the security deposit, your contract with the lessee required some part on your part before you gave him any money. Like, did you collect the keys, garage door openers, and other electronic services from? No?
No, we did not.
Did you inspect the premises at all to make sure there was no damage to it?
No, we did not.
Did you make sure the kitchen appliances were cleaned?
No, we did not.
Okay. Did you make sure every term of the return of the security deposit was taken care of under that? Were you relying on that contract? Did you do that? Did you do anything?
As soon as we could find out that he had indeed moved and that the security deposit had already been returned to him, then we immediately refunded the security deposit.
From May to November, you said you didn't have any conversations or contact. You didn't go over there. You have no really idea when he moved out, do you?
That's
you have
true.
No idea. Okay.
Yes.
You didn't do anything under the terms of either contract at all, right?
That's correct.
And from January, or from November to May, the only thing you did was you said, well, on one occasion you said you called the tenant 50 times, another occasion you said you talked to him occasionally. I'm not sure which one it is, but that's all you did then. Is that right? From November to May, right?
That is correct.
Now, I have a copy of an email from Ms. Carpenter sent to you on November the 15th, and it says...
Is that the one that was actually sent or the one that she
that was
prepared
sent.
and did
She
not
said,
send?
I have a copy of it. It was
Okay.
sent to you. Last evening, remember...
Let's show the document to him.
It's in the... Okay, I'd be happy to.
Is it in the...
It is in the exhibit.
Thank
you.
All right. Is it in this email exchange that we first come to here?
Sorry?
Where is it?
How do we find it?
It's a copy of the exhibit. In a moment, I'll tell you what page.
Pages aren't numbered.
You want me to start with last evening?
Hold on just a
Okay.
second.
What's the date of it, Mr. Hill?
November the 15th.
About 6, 7 pages into. It's only four? Yeah. Four pages into.
Okay.
At the top, I believe this email was prepared and not sent.
No, it says sent November 15, 2011 at 4:41 p.m.
Okay.
Okay, read down. However, my message has changed. How changed? And I'm going to read this to you, and I'm going to ask you some questions about it. Last evening, Monday, November 14th, you spoke with my fiancé. After attempting to persuade him to convince me that $250 was a reasonable fee for us to pay you in order to mutually agree to end our contract, you once again said our November rent check was in the mail. As you stated in your email dated November 9th, you then told him you were 98% sure you had signed it. You also told me you were surprised as why I'm unsatisfied with the service provided by Christian Realty. When I arrived at your office today, once again having to leave work and drive 25 miles to pick up our check, only to be told by the reception bookkeeper at the front desk that the check had not been written yet. To clarify, I asked if she meant another check because the first one was sent out but not received. She said no, that she had been on vacation last week and the check had not been written. Gaius, after apologizing to me for being unhappy with your service and asking if I wanted to sit down and discuss, I told you no, that we only needed to correspond through email. Much like my request to have renter move in on Monday, September 19th, instead of Friday, September 16th, you ignored my request, continued talking, and asked if I had spoken with Tommy about our conversation. You said that there are expenses you've accrued from providing a service thus far. I asked if you would email me those expenses. You said you would not, then started to explain the cost of your overhead. I called Tommy on the phone because I did not feel comfortable speaking to you with just your reception present. Then let me stop. Why didn't you send, if there were expenses she owed you, why didn't you send her a list of expenses she owed you if you had such an issue with it?
Emma, I'm not sure what this has to do with the escrow, but I certainly would have sent her a list of expenses had she requested it. She said I did not. She said you have not sent me the list of expenses.
That's exactly right.
Okay.
You said, and that she said, you said you wouldn't do it.
Well, that's not true.
Okay. Gaius, you're quite correct. I am extremely 100% unsatisfied with the service of Christian Realty. Your misleading and false information has now cost me money, time, and exhausted my patience. I have no desire to sit and have a conversation with someone, especially one that I'm paying to provide a service, to discuss how much I should pay to be released from a contract in which your company continues to fail to adhere to. This email serves as a second request to send the escrow check for the renter at the property, I can't pronounce it, it's Callias, Antioch, to the previously provided address, along with a contract release statement. This letter also serves as notice of my intent to file a complaint with the Tennessee Real Estate Commission if the check is not received on or before the previously discussed date. Signed, Tracy Carpenter. Did you send a contract release statement?
Did I send a contract release statement?
That's right. No, you
no,
didn't.
I did not.
Okay. Then I see if you go up on the page before that, there's an email from Tracy Carpenter, Monday, November 21st. Okay. It says, due to no response to the second request to send the escrow account, I'm immediately terminating our contract of property management services. Please immediately release the escrow security deposit for the property and the check made out to Parks Property Management. And did you do that? Did you send a release, a contract release, and send it to Parks Realty?
I couldn't really understand this email, so I took no action. The email, it says, due to no response of the second request, I'm immediately terminating the contract. This is sent 22 days after she told me she was terminating the contract.
Well, no, sir.
So
I see that the
I'm sorry.
The previous email when she said she was terminating was November 15, 2011. This was November 21st.
I think the first one was October 31st, you told me. Is that right?
Yes, and she sent it again November 15th, and then again November 21st.
I'm sorry, I'm not trying to fight with you here. I just wanted to understand what this email made no sense to me, quite frankly.
Well, it looks like your response to the email is above. It says, we have discussed this. How do you unilaterally terminate a contract with no remuneration? I was hoping to settle this without legal representation. However, I can no longer afford to allow everyone to take advantage of my company without paying what they owe. My attorney's name is Todd Jackson. You should be hearing from him soon. Thank you. That's your response to this email?
Yes, it is.
That's your response to request to send
yes.
a security deposit, is that you're owed money. That's your response.
My response, that is part of my response, yes.
And that's part of the reason you couldn't release that security deposit? Because you were owed money. That's what
What?
you say there.
No.
Is that not what you just said?
No, that's
In
not
that
what I
e-
just said.
Well, what does it say in that email?
It said the termination of the contract and the escrow money are, to me, are two totally separate issues.
In response to the email, when she
Now,
asked...
let him finish his answer before you throw another question at him,
Okay.
Ms. Ryan.
Well, what I said in my email is that I would not allow her to unilaterally terminate this contract because I felt like our company, that she owed me money because our expenses had exceeded, in this case, what we had received. And I let everyone know through this email and later on through to the Tennessee Real Estate Commission receiving these emails that Todd Jackson, I was in touch with Todd Jackson during this entire process. I was trying to get advice of an attorney and do the right thing.
But it was a response to her saying that there was no response to the second request to send the escrow check.
That's correct.
The only thing you say is that you're owed money.
Yes. Is it?
Okay.
Are you saying I should have sent the escrow check with this from this email? Is that what you're?
I'm suggesting that you were holding a third party's money
Okay.
hostage for money you were owed by the property management group. That is what I'm suggesting.
I don't.
I have nothing further.
I didn't mean it that way, but.
Gaius, you've been a realtor for a while. Can you change a real estate contract by verbal agreement?
If I could, I'd probably be wealthy now.
Yes.
I cannot.
So is there a writing signed by you that terminates this contract?
There is not.
So it's your opinion that this contract was still in force until July,
Absolutely.
and you did not get paid for the rents that were paid during that time?
I did not.
Did you get all these emails that she's put in her complaint?
I got most of them. I think some were prepared and not sent, and then were sent at a later date. But I did eventually get them all. Yes.
So when she's got some of these that say email not sent, what did you understand that to mean?
Once she started complaining, I didn't know what it meant. I thought maybe once she started complaining early on to the Better Business Bureau, which we went through the same type of hearing with them, not exactly this, but and Tennessee Consumer Affairs, we went through that. I thought it may be to bolster her arguments. I really didn't know.
Your understanding of your contract and your lease, did any of that, and she seems to be tied up on your property management contract, but in your opinion and your understanding, did any of that do anything to release you from the lease, your obligations on the lease?
No, I felt like they're two totally different things.
And your obligation as to the security deposit under the lease, what was your understanding with that?
That I have to hold that security deposit in an escrow account, non-interest-bearing escrow account, until such time as that lease is satisfied or I'm relieved of that through some proper documentation.
You did not receive any proper estoppel, assignment of lease, anything that takes you off of that lease?
My opinion is that he could have sued me and won had I released this money.
Nothing further, Your Honor.
All right. Any member of the commission have a question for the witness?
I've got just a couple more. When's the last time you had any continuing education?
About 3 weeks ago.
And what was that in?
We redid I've done the Code of Ethics twice in the last 4 years.
Is that the only type training you've had in the last few years, or?
Well, in terms of formal accredited training, yes, the Code of Ethics would be the only thing in the last few years. School of Hard Knocks, I've developed several properties and done a lot of contracts and tried to do the right thing by people, but not formally, no.
Have you had any kind of education in property management to know what the landlord-tenant law is or anything like that?
Yes, ma'am.
And when was that?
I read the entire Landlord-Tenant Act.
When?
I've read it every year for the last 3 years.
Okay.
Other questions? All right, we're done with Mr. Hill.
I am.
All right. Mr. Hill, take your seat back with
Thank you.
your counsel there. Any other proof, Ms. Ryan?
No, Your Honor, I do have a closing.
Okay. Anything else you wanted to present, Mr. Jackson?
No, Your Honor.
All right. So we still have the motion to continue the hearing to allow the testimony of the complainant who's not here. Let's let the board address that before we go further.
Chairman, I think we've heard enough, or at least I've heard enough. I don't see a need for continuance.
I move to deny the motion to continue.
Second.
Commissioner McMullen makes a motion to deny the continuance, and it's been seconded by Commissioner Northern. Any discussion on the motion to deny continuance? Hearing no discussion, all in favor say aye.
Aye.
Opposed, no. Motion carries unanimously.
All right. Thank you, Ms. Stevens. So the motion continues, been denied, so we'll hear closing arguments from Ms. Ryan.
Facts in the case are really. He had a contract with someone who owned property to manage that property. She was not happy with that. She asked for termination of that contract. And whether he agreed or not, he did quit doing anything under that contract. He also had a contract with the lessee as a result of the contract he had with the owner of the property. He also had an obligation on that contract, and he didn't do that either after November 11th. He didn't collect money, didn't collect rent, didn't make sure the property was in order, didn't do anything on either property, but kept the security deposit in his bank because no matter what he says, everything we have indicates he's mad about being released and he thinks he's owed money. That security deposit doesn't belong to him, doesn't even belong to Miss Smith. It is a security deposit that goes with the property and would have been in another account had he put it there like he was requested when she changed companies. And as far as a contract to terminate, she asked him to send him one, and he didn't do that. Each, if you read all of them, each of her requests concerning the escrow money and requesting to send it to a new company is met with, "You owe me money." I suggest to you that he had no right to do that at all. And I further suggest to you, despite what he says about keeping the money in escrow account, the prudent thing to do would, to follow up, he could have found out very easily. He was told who the management company was. It was Parks Realty. He knew that was in place. Could have followed that up. Could have sent the contract like he had been asked. Could have paid the money over there, and then we wouldn't have had this argument at all, and that money still would have been protected, since, of course, the tenant wasn't paying money to him anymore anyway. And he wasn't doing anything under the lease agreement. He wasn't doing anything under the management agreement. This complaint was filed in July of this year. So he knows there's an issue. Does he address it? When does he address it, finally? November. In November. Requests have been made to pay that money over the escrow account. We don't know, because we don't have Ms. Carpenter-Smith, when the tenant left. We do know that as far as the contract was concerned, he had some certain obligations to release the funds, but of course he didn't follow those either because he wasn't doing anything. He was simply mad that she wanted out of the contract. And I can understand that you have difficult people. As attorneys, we have difficult clients all the time. But no one has the right to keep money belonging to others because of a conflict you might have. And is this the type of people we want managing persons' monies out there? Someone who thinks he's entitled and therefore he's keeping it hostage. Is this the type of person we want who, when filed with the complaint in July and after numerous requests, still doesn't do anything about it? Till somehow in November he finally figures about time and oh yeah, the guy's out of the property. Well, okay. And finds out that the security deposit was paid back to him, and he really better have at that time in November pay that money. That's not sloppy by itself. That is also inconsiderate, unethical, and I suggest in violation of your laws that say you must remit or account for money in a timely fashion. And I suggest from November of 2011 to November of 2012, is not timely. Thank you.
Ms. Jack?
All of that's interesting, but it doesn't change the fact that if Mr. Hill had done what he was asked to do in the manner that he was asked to do it, he'd probably be before you with more serious charges. So he was put in an impossible situation. There was no request to assign that lease to get him out of it. And I would guess, and I've talked to him about this, he would have loved to have been out of that. There are ways to do things. We're a country of laws. Realtors have rules. He doesn't get to decide and pick and choose which ones to comply with. If he's guilty of anything, it's trying to do the right thing by his obligations under his lease. The lease terminated on September 30th. Until that day, he was still responsible for that money. He was protecting the consumer tenant, period. If he's got a customer that's difficult, we all do, like Ms. Ryan said. That doesn't change the fact that we've got obligations. None of what happened in that background changed the fact that he had a lease in his name and he was responsible for that money. He didn't take that money and go buy a car with it or go on vacation. That money stayed where it was supposed to be. It was protected. And the day that he figured out all of the conditions were complied with under the lease for return of that money, he returned it that day. There was no, hey, this is my money, I'm going to do something different with it. That never happened. Now, I don't think this is really all that important to the discussion. I think the issue is much more narrow, but I'd be mad. I spent months trying to find a tenant for somebody that hired me to lease the house for them. I leased it, found a good tenant, and 30 days later they decide they don't need me anymore. I'd absolutely be mad, and I wouldn't hide it. It doesn't change anything. It doesn't change the fact that he was still obligated to do with that money exactly what he did. If what he did is actionable, I would submit that your phones are going to be ringing a lot from realtors saying, wait a minute, that was an impossible choice. I was presented with a false choice. Either I do what this customer demands of me, which I knew wasn't right, or I've got a tenant complaining about me because I did something with his security deposit that I wasn't supposed to do. I think he made the right choice. Knowing that this was going to happen, knowing that she said exactly what she was going to do if he didn't do it, and he said, you know what, I'd rather have that happen than the alternative. And for that reason, I think that what he did was correct and should not be found in violation of the rules. Thank you for your time.
Thank you, Ms. Jackson. Do you have a proposed order to publish to the board?
I have proposed findings of facts and conclusions.
All right, you can publish that and hand Mr. Jackson a copy of it if you haven't already. Ms. Jackson, I'm assuming you didn't prepare anything. The state typically does, is the reason I ask. And so we'll publish that to the board. And members of the board, I'll read you a instruction and turn the matter back over to you for deliberation. And I'll go ahead, since Ms. Ryan's distributing that. If in these instructions any direction is repeated or stated in varying way, it is for clarity and not special emphasis. You are not to single out any certain sentence, individual point, or instruction and ignore others, but are to regard each in the light of the other. The order in which these instructions are given does not signify their relative importance and has no significance as to their relevant importance. You are the exclusive judges of the facts in this case. You are also the exclusive judges of the law, specifically your statutes and regulations and their application in this case. You should apply the law to the facts in deciding this case under the direction of these charges. The state has charged the respondent with certain violations of your statutes and rules. For each of these charges, you must reach a determination whether or not the respondent is guilty of this conduct. And in your finding of facts, give the underlying facts that support that decision. In reaching your decision, it may be necessary for you to interpret your statutes and rules. When the language of the statute or rule is plain, then you must follow the plain meaning of that language. However, if the language is ambiguous, you may give your interpretation of that language so as to explain the conclusion you reach as to the violations charged. You exclusively have the authority to make findings of fact and reach conclusions of law in this matter. No one else can participate in your deliberations. The state the state must, you must first determine whether or not the state has met its burden of proving its charges by a preponderance of the evidence or as the more probable conclusion. The preponderance of the evidence standard means the amount of factual information presented to you in this hearing which is sufficient to cause you to believe that the allegation is probably true. If you find the evidence to be equally balanced, then the state has not proven the allegations, and you must find that it's failed to do so. Any motion to find particular facts or on the charges are carried by a simple majority of the commission, vote of the commission. The evidence in this case includes the testimony of the witnesses, any facts stipulated by the parties, and documents introduced into evidence. Documents filed by the attorneys for the state and the respondents, such as notice of charge or proposed findings of facts and conclusion of law, are not evidence. The notice of charges was presented to you to give you some understanding of why we were having the hearing today, and the proposal submitted by the state of findings of facts and conclusions of law submitted to you as the state's interpretation of what it believes it proved. You can use these documents, though, as a guide to help you find your facts and conclusions of law if you find it appropriate, but do not allow it to substitute for your own judgment. Statements, arguments, and remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statement were made that you believe was not supported by evidence presented, then you must disregard them. Questions posed by counsel to witnesses are not evidence, may be considered, however, to the extent that they supply meaning to the witness's testimony. Although you may only consider the competent evidence presented during the hearing in making your decision, this does not mean that you are required to set aside your common knowledge or expertise in the field of real estate. You may and in fact should weigh the evidence in light of your training and your own observations and experience. If you determine that the state has shown has proven by preponderance of the evidence what is alleged in the notice of charges, then you must next determine what is the appropriate action for the commission to take. Again, this is determined by a simple majority vote of the board. You should consider such things as whether the conduct allegedly was or is of a continuing nature or a one-time offense. You also should consider what has been done in previous similar cases. Bear in mind that you will need to give a policy reason which supports your decision of the action you take. Under the law, administrative agencies are not required to have absolute consistency in their actions they take. However, this does not mean that you may be arbitrary and capricious in dealing out disciplinary action. Disciplinary action must be based on fairness and reason. Your policy reason is your statement explaining why the particular disciplinary action you chose in this case is correct given the wide range of cases you hear and the various disciplinary options you have. It tells the public and reviewing courts why this particular action you chose is proper, even though it may be a little different from what you've done in the past or may do in the future. The gravity of the violation, respondent's attitude toward the action, and the nature of the offense may be included in your policy statement to support your disciplinary action. This does not have to be a long statement. However, it should not just be a reiteration of the facts you have found in the case. All right. With that, Chairman Stevenson, I'll turn the matter back over to you for deliberation, and the board has four obligations. It needs to find facts and conclusions of law. Secondly, conclusions of law. Determine whether, what, if any, disciplinary action is appropriate, and finally, lastly, the fourth step would be to make a policy reason statement.
Your Honor, at this time, I want to ask some guidance from the Commission. I know it's right now 15 to 12. I don't know how long it's going to take us to go through these four motions or four things that we've got to decide. Do we want to take a break and before we start deliberating for the comfort of everybody? Because yes, I have already talked to our educational director, Mr. Steve McDonald, and he would like, I know it's customary that at around 12 o'clock that we let the licensees go on this second day. If you want to stay, you can and watch our deliberation, but I have one commissioner has asked that we take a break before we come back and start our deliberations. And is that okay with everybody on the commission?
How long a break are we talking?
Just 10 minutes.
Okay.
And then
We'll work through lunch.
And we'll work through lunch. We'll stay here until we get this finished.
Can I ask the Judge one?
Yes, yes, you can.
So whether we think the preponderance of evidence is sufficient or not, we have to go through those 4 steps?
No, well, if you don't find, your first step's always to determine whether or not the state has proven the factual allegations in the notice of charges, and you always have to find the law. Now, if you found that the state did not prove the allegations, then there would be no disciplinary action would be appropriate. You would still have or I guess your disciplinary action would be none.
Well, would you have to have findings of facts in that case and policy statements?
You always have to have findings of facts and conclusions of law.
Regardless of our decision.
Correct.
Okay, thank you.
And your findings of fact would be either it occurred or it didn't occur, or so forth.
Right, thank you.
Thank you, Your Honor. We're going to take a 10-minute break. You licensees, we hope, Kelly. I call these proceedings back into session. You have heard the judge give us the charge that how we are to proceed with finishing this formal hearing. And at this time, I would open the floor up to any discussion that anybody would like to bring before the commission.
I yield my time to Commissioner McMullen.
Mr. Chairman, I move that we make the following finding of fact: that the respondent was at all times pertinent hereto licensed with the Tennessee Real Estate Commission, having been issued license number 21873.
I'd like to put that in form of a motion that we do find that that is a factual statement.
So moved.
Second.
I have a motion by Commissioner Grease, seconded by Commissioner Northern, that number 1, which Commissioner McMullen has read into the record, is true. Any discussion? All in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move that we make the following finding of fact: respondent was at all times pertinent hereto, principal broker of Christian Realty, a licensed real estate firm.
Second.
Commissioner McMullen makes a motion that what he has just read into the record is true. Seconded by Commissioner Grease. Any discussion? Hearing none. All in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move that we make the following finding of fact: on or about July 6, 2011, complainant and Christian Realty entered into a property management agreement for complainant's property located at 3413 Calais Circle, Antioch, Tennessee 37013.
Second.
Motion by Commissioner McMullen and seconded by Commissioner Grease. What Commissioner McMullen has read into the record. Any discussion? Hearing none. All in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move that we make the following finding of fact: on or about September 14, 2011, Jeffrey Gray entered into a lease agreement with respondent on behalf of Christian Realty to rent the subject property owned by complainant.
Second.
I have a motion by Commissioner McMullen, second by Commissioner Northern, that what Commissioner McMullen read into the record is true. Any discussion? Hearing none. All in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move that we make the following finding of fact: pursuant to the lease agreement, Jeffrey Gray agreed to pay unto respondent a security deposit of $1,050 and monthly rent in the amount of $1,050.
Second.
Motion by Commissioner McMullen, seconded by Commissioner Northern, to what he has read into the record. Any discussion on this motion? Hearing none. All in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move we make the following finding of fact: at the time that Jeffrey Gray entered into the lease agreement, Jeffrey Gray paid the $1,050 security deposit, which was deposited into Christian Realty's escrow account on or about September 14, 2011.
Second.
Motion by Commissioner McMullen and seconded by Commissioner Northern, of what he has read into the record. Any discussion on this motion? Hearing none. All in favor say aye. Opposed, no. Motion carries.
Mr. Chairman, I move we make the following finding of fact: on October 31, 2011, complainant notified respondent in writing via electronic mail that complainant was terminating Christian Realty's property management services for 3413 Calais Circle, Antioch, Tennessee 37013, effective November 30, 2011.
Second.
Have a motion by Commissioner McMullen and seconded by Commissioner DeShara. What has been read into the record? Any discussion?
Mr. Chairman?
Commissioner Grease.
Just for clarification, I mean, the finding of fact is that, in my mind, it's more she was attempting to terminate. Are we making a judgment if we vote for this that she did terminate it?
What if I rephrase the proposed finding?
Yeah.
Okay. So I'll withdraw that motion and make the following motion. On October 31, 2011, complainant notified respondent in writing via electronic mail requesting termination of Christian Realty's property management services for 3413 Calais Circle, Antioch, Tennessee 37013, to be effective November 30, 2011.
Second.
Motion by Commissioner McMullen and seconded by Commissioner Grease. Any discussion on this motion? All in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move that we make the following finding of fact. On November 3, 2011, complainant submitted a request to respondent in writing via electronic mail for a release of the security deposit paid for 3413 Calais Circle, Antioch, Tennessee 37013.
Second.
Commissioner McMullen has made the motion. You've heard it read. Commissioner Northern seconded that motion. Any discussion on the motion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move that we make the following proposed finding of fact. On November 15, 2011, complainant submitted a request to respondent in writing via electronic mail for a release of the security deposit paid for 3413 Calais Circle, Antioch, Tennessee 37013.
Have a motion by Commissioner McMullen, seconded by Commissioner DeShara. Heard it read in the record. Any discussion on this motion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move we make the following finding of fact. On November 21, 2011, complainant requested in writing via email to respondent the termination of Christian Realty's property management services for 3413 Calais Circle, Antioch, Tennessee 37013, effective immediately, and requesting respondent's release of the security deposit for that property.
Second.
Have a motion and a second. Motion by Commissioner McMullen, seconded by Commissioner DeShara. Any discussion on this motion?
I don't remember the effective immediately, but maybe it was.
Do I hear that you have some
No, go ahead.
discussion?
Go ahead.
Hearing none, all in favor say aye. Opposed, no. Motion carries.
Mr. Chairman, I move we make the following finding of fact. On November 21, 2011, complainant requested that the security deposit be transferred to Parks Property Management, Brentwood, Tennessee.
Second.
Have a motion by Commissioner McMullen and seconded by Commissioner DeShara. Any discussion on this motion? All in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move that we make the following proposed finding of fact. In response to the November 21st, 2011 request from the complainant, the respondent did not investigate whether the complainant had a management agreement in place with Parks Property Management.
Second.
A motion and a second. The record show what Commissioner McMullen has read into the record and seconded by Commissioner Northern. Any discussion on this motion? Hearing none, all in favor say aye. Opposed, no. Motion carries.
Mr. Chairman, I move that we make the following proposed finding of fact. The respondent did not manage the property after the complainant's request for termination of the management agreement.
Second.
Motion and a second. Motion by Commissioner McMullen, seconded by Commissioner Northern. Any discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries unanimously.
Mr. Chairman, I move we make the following finding of fact. The respondent was not collecting rent on the property after November 2011.
Second.
Motion by Commissioner McMullen, second by Commissioner Northern. Any discussion on this motion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move we make the following finding of fact. On and after November 2011, the respondent assumed that a management agreement was in place between the complainant and Parks Property Management.
Second.
Motion by Commissioner McMullen, seconded by Commissioner DeShara. Any discussion on this motion?
I just, is that based on testimony? I don't recall that, but.
Well, it's based on my interpretation of his testimony that he didn't collect the rent, and he asked the tenant, "Are you paying the rent?" And the tenant said yes, and that was satisfactory to the respondent. And also, the document we have that I think this was a document that the respondent provided to the state on the second page on November 13, 2012. It says that the respondent reached Jeffrey Gray after many attempts and was told he had moved. He also discovered that he had received a return of the deposit from the complainant, and it said Ron Harmon at Bob Parks Realty said that the complainant had written a check for return of the deposit. And so I feel like he must have believed that Ron Harmon was the management agent who was in place based on that.
Can we say that he assumed that someone other than his management company was handling it rather than Parks, because that didn't take place until later on?
It's fine with me.
I'm not sure that I couldn't draw the same conclusion that maybe the owner was collecting the rent and not a management company. Just know he wasn't.
Right.
Well, and the other thing that comes to mind for me is just the complainant asked that the money be sent to Parks, and at that point he stopped doing anything, and he assumed somebody else was doing it, obviously, and he wasn't doing it, and he asked the tenant, "Are you paying rent?" Yes.
That's why I'm saying someone other than himself,
Yeah.
rather than specifically Parks.
Well,
I'll withdraw the motion and make a new motion. How about that?
I seconded that motion, and I agree with you. I think that because the email indicated it was Parks, I think that he accepted that. I don't think he ever denied that Parks was in control of it, because he never questioned where the rent was going.
Question I have, at what point did Mr. Hill, at what point did Mr. Hill realize that Parks was in fact managing the testimony? At what point, or approximately what date did he become aware of that?
I think absolutely by November 13, 2012, because that's the day he said he spoke to somebody at
Right,
Parks
yeah.
and was told that the lady had paid the money, and he accepted that at face value. So the question is, at what point before that did he become aware? And it could be as early as an email from the complainant in November of 2011 saying send the money to Parks, or somewhere in between. I don't know, maybe in conversations with the tenant he might have asked, where did you send the money? We don't have any clarity on that. I think it's reasonable to interpret it several different ways there based on the evidence, in my opinion.
And Mr. Hill never denied that he felt like Parks was managing the property.
So if you'll would you like to withdraw your second? Because I know, based on the discussion, Commissioner McMullen has indicated he'd like to rephrase his motion. Did I hear you say that, Commissioner McMullen?
I'm comfortable with my motion, but if other people are not, I'm comfortable rephrasing the motion as well. And I think that Ms. DeChara is comfortable with it. I don't know, if we want to go ahead and vote on it, or
Commissioner Collins just.
I wish you'd rephrase it, because
Okay.
I think that all parties should have notified somebody. The park should have told them that, hey, we've got an agreement here. We won't take care of it from now.
Well, of course, we didn't have Parks here to get any testimony from
That's not our
Parks,
fault,
so
though.
we don't know whether that was actually relayed or not. But I'm
Speculation.
comfortable, Austin, with
that's-
you.
we've already accepted that the respondent wasn't managing the property. So it may not really be that relevant who was managing it afterwards. He wasn't doing it. And that maybe we just move on.
Would you read your original
My
motion?
original motion was that the respondent assumed that a management agreement was in place between the complainant and Parks Property Management on and after November 2011.
I personally am not comfortable finding a fact on an assumption, I guess. It's just not so clear. I'd rather not have it as a fact.
I'm going to withdraw my motion and make another motion if I can.
You can, Commissioner McMullen.
Mr. Chairman, I move that we adopt the following finding of fact. There is no dispute that Mr. Gray stayed in the leased premises until the end of the lease term. At that time, he was entitled to a return of his deposit pursuant to paragraph 3 of the lease.
Second.
A motion by Commissioner McMullen has been read into the record, and seconded by Commissioner DeShara. Any discussion?
I'm not trying to be adversarial, but the lease also says if he doesn't give 60 days notice, it becomes a month-to-month lease. And I don't have any proof that the notice was ever given to any party.
I made the motion the way I did, just saying that there's no dispute because there's nobody who's come in here and said any of those kind of facts. I mean, there's 6 or 7 different things under paragraph 3 that could have prohibited him from getting the money back, but everybody who's come in here today and talked to us said that they assumed, and it appears that the complainant paid the money to him, he was entitled to it, and now it's just a question of what about this security deposit. That's where I'm coming from.
Okay. Any other discussion on this motion that Commissioner McMullen has entered into the record? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries.
Mr. Chairman, I move that we make the following finding of fact. On November 13, 2012, respondent learned that Mr. Gray had moved out of the leased premises and that the complainant had paid Mr. Gray $1,050 representing the return of his security deposit. He learned these matters through communication with Mr. Gray and Ron Harmon at Parks Property Management.
I think he paid that money to Ms. Smith, Carpenter Smith, didn't he?
My motion, though, talks about that the complainant had paid Mr. Gray the money.
I'm sorry. I thought you said
second.
I'm sorry.
Okay.
I have a motion by Commissioner McMullen. It's been seconded by Commissioner Grease. Any other discussion on this motion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries.
Mr. Chairman, I move we make the following finding of fact. On November 13, 2012, the respondent remitted the $1,050 security deposit to the complainant.
Second.
Motion by Commissioner McMullen and seconded by Commissioner Grease. Any discussion? All in favor say aye. Aye. Opposed, no. Motion carries.
Mr. Chairman, that's all the findings of fact that I have. I don't know if anybody else has any or not.
Thank you, Commissioner McMullen. Does anyone else, based on the testimony that we have heard, want to put a motion on the floor as to additional findings of fact?
I'd like to make a motion that I didn't see any, in the allegation of facts, any violation on the part of the respondent.
We're right now.
I know where you are.
I know where we are. We'll get to that in a minute. Any other findings of fact?
Mr. Chairman, I'd like to add one more finding of fact, and that is that in no case there's no evidence that the respondent ever agreed to terminate the management agreement.
I'll second that.
We have a motion that Commissioner Grease has added to the findings of fact, which is at no point in the testimony did the respondent terminate the management lease that he had.
I think that the actions of Mr. Hill indicated that he was in agreement to terminate the lease because he did not continue to collect rent or maintain the property.
I agree with that. I think that, to me, it seems like it was terminated in November 2011 when the complainant requested termination, and then he stopped doing anything under the agreement. And so, to me, it seems like it was terminated at that point because he wasn't doing anything. She had requested termination, so his actions indicated that he assented to her request. That's my view of it.
I understand that view, but in fact, my sense of it is that the owner told the tenant to start sending a check to somebody else.
Right.
I don't believe this manager instituted any of those actions on his own. I think it was, in my opinion, directed by the landlord/owner of the property.
But he didn't continue to maintain the property or make any efforts to do that either.
Don't disagree with that. That may be part of your findings of fact. But to say that I just can't agree that his inactions were a cause to terminate an agreement when, frankly, the actions of the complainant were what caused this chain of events. At least in my opinion, my belief.
She asked for a release to be sent, and having a property management company, I know that once we get that request, that, you've got to take some kind of steps to stop that from happening.
But can I ask Commissioner Grease to repeat his motion? I think what I heard I can agree with, because I understood him to say that he did not agree to it, and I've not seen anything that said he agreed to it. Now, whether or not he actually performed the duties under it is another issue.
Right, but maybe the court reporter could read it back. Maybe not, the way I stumbled through it. But the intent of the finding of fact is that at no time did the management company agree to release the contract, the management contract.
If we have the motion, I think everybody understands what this motion is, and we have a second by Commissioner Haynes. It's just like, I don't do property management, so I'm sort of at loss with this kind of segment of the real estate industry. But it's just like having a listing agreement. Somebody signs a listing agreement to you for for a year, legal binding document. 2 months into the listing agreement, they call you up and say, I don't want you to have my property listed anymore. You don't have to terminate it. They've signed a legal binding contract that will run for a year. You can keep that property legally listed for a year. And just like, this...
You can't sell it, but you can keep it listed.
You can keep it listed. Yeah, you can tie it up, and I feel Commissioner agrees.
It takes two to get into the contract and two to get out of the contract.
Yeah.
And the point is, he made an agreement to list it for her, and she's still collecting rent. So part of his job is continuing. She's still getting her money.
Any other discussion on the motion that Commissioner Grease has made and seconded by Commissioner Haynes? Hearing none, all in favor say aye. Aye. Opposed, no.
No.
We have 6 ayes and 1 no.
No, Austin.
2 noes. 5 yeses and 2 noes. Anybody else have any findings of fact that they'd like to make a motion about and have read into the record?
Was there something in there, Austin, that, I guess that was in there, because he was in a legal agreement that the security deposit was deposited with his company under the lease, and that you covered that. Okay.
I'll add one additional finding of fact, and that is that respondent did hold money belonging to another party after being requested to transfer those funds based on his understanding that he was treated unfairly.
I'll second that.
We have a motion made by Commissioner Northern, seconded by Commissioner DeShara. Robert's Rules of Order says that the chairman's supposed to repeat the motion that has just been made, and I'm not going to repeat these motions because I can't. Y'all have got to pay attention to these motions that are being made. Any discussion on this motion by Commissioner Northern?
Can you
Can you repeat that?
Sorry.
Not verbatim, but I will tell you again what I'm saying, and that is that the respondent did hold the earnest money after being requested to transfer the funds because of, I'm going to say,
Do we have to say because?
well,
Or just stop it?
yeah, we can stop it there.
Because that's the because is what worried me,
Okay.
to be honest, because I don't know because.
Well, it's his
Because
testimony.
he was-
His testimony,
Wanted
to me, made it sound like he was acting on emotions and perhaps advice from an attorney. But regardless, he held the funds beyond the time that it was requested.
Now, I'd go for that motion if you stopped right there and left the because off.
I'll go with that motion, but I've got a follow-up finding of fact to go with that.
Okay, we're in the
Well, I
discussion phase.
seconded it, so we're good.
On the question, I got a question on this discussion. Have we voted to talk about it yet?
No.
Okay.
Motion and a second's on the floor. We haven't voted to Mr. Northern's motion. Hearing no other discussion, all in favor say aye. Aye. Opposed, no. Motion carries. Commissioner Grease.
All right, I'd like to offer a finding of fact that states, at no time did the tenant ever ask the management company to release the security deposit.
I'll second that.
I don't know that we know that.
Have a motion
No
by,
proof that they did.
We don't have any, that's right, we can't find a fact that we don't have any proof he did or he didn't. We don't know when the tenant asked for his money.
I think the testimony that we've heard did not include that.
But it should have.
Well, no.
Would you be willing to withdraw your motion and let me?
Sure. I'm just trying to get the point across, whatever the best way to do it.
Mr. Chairman, I propose we make the following finding, or make a motion that we adopt the following finding of fact. There is no evidence in the record that the tenant requested a return of the security deposit from the respondent.
I'm good with that.
Second.
Second by Commissioner Northern. Commissioner McMullen makes the motion. Any discussion on this motion? Hearing none, all in favor say aye. Aye. Opposed, no. Started to rephrase it. Any,
Do we move on to deliberations at this point?
if nobody else
Well, I think
has any,
Austin-
Are you
has any findings of fact,
I've got some conclusions.
Ready for that?
does anybody have any other findings of fact based on the testimony in this case that want to be read into the record, or any motions to be made? If not, then this will conclude our deliberations on findings of facts, and now we go into the deliberations on the conclusion of law in this matter.
Mr. Chairman, I move that we make the following conclusion of law. TCA 62-13-312B5 provides that the Commission shall have the power to refuse a license for cause or to suspend or revoke a license where it has been obtained by false representation or by fraudulent act or conduct, or where a licensee in performing or attempting to perform any of the acts mentioned herein is found guilty of failing within a reasonable time to account for or to remit any monies coming into the licensee's possession which belong to others.
I second that.
Have a motion read in the record by Commissioner McMullen and seconded by Commissioner DeShara. Any discussion on what Commissioner McMullen has read into the record?
So we're in the conclusions of law. I mean, that's the law. I mean, we agree that's the law if we vote yes?
Is that all we're agreeing is that is the law?
That wasn't hard at all. I'm ready to vote on
We
that
don't know
one.
about attorneys.
read directly from the statute. Hearing no more discussion, all in favor say aye. Aye. Opposed, no. Motion carries.
Mr. Chairman, I move that we make the following conclusion of law. TCA 62-13-403-6 provides that a licensee who provides real estate services in a real estate transaction shall owe all parties to such transaction the following duties, except as provided otherwise by Section 62-13-405. In addition to other duties specifically set forth in this chapter or the rules of the Commission, timely account for trust fund deposits and all other property received from any party to the transaction.
Second.
Commissioner McMullen's read into the record under the conclusions of law, and seconded by Commissioner DeShara. Any discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move we make the following conclusion of law. Rule 1260-.02-.09 6A provides that a broker may properly disperse funds from an escrow account upon a reasonable interpretation of the contract which authorizes him to hold such funds.
Second.
Commissioner McMullen has made the motion, read into the record, seconded by Commissioner DeShara. Any discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move that we make the following conclusion of law. Rule 1260-.02-.09 7 provides that funds in escrow or trustee accounts shall be dispersed in a proper manner without unreasonable delay. Funds should be dispersed or interpled within 21 calendar days from the date of receipt of a written request for disbursement of earnest money.
Second.
Motion by Commissioner McMullen, seconded by Commissioner Northern. Any discussion?
Well, this relates to earnest money, right?
That's what it says.
And this is not
This
earnest
is not
money.
earnest money.
I'd have to vote no on that motion.
Well, it says escrow or trustee accounts. Funds in escrow or trustee accounts.
Earnest money, security deposit.
Read that again, Commissioner McMullen.
The rule says, funds in escrow or trustee accounts shall be dispersed in a proper manner without unreasonable delay. Funds should be dispersed or interpled within 21 calendar days from the date of receipt of a written request for disbursement of earnest money.
Earnest money.
But it was in his escrow account.
But it's earnest money.
Speaking to
It
escrow
doesn't say
accounts.
earnest money and security deposits. It says earnest money.
I'm just asking, can we all agree that that's what the rule says? And then we can debate what the impact of that is.
Rule says what it is what it is. Do I?
Can I ask you a question about, is written included email?
Yes.
I'm asking I'm an attorney.
Well, you don't have to. It's in the law.
I think I've never really spent a lot of time researching that issue, but I think that emails are considered written requests, I think.
Without signature.
Right.
Okay.
Because the rule doesn't say in writing signed by the party to be charged or something like that.
Julie, has that not been added as a form of notification in our rules, email?
You aren't supposed to be asking that.
I really don't think that, I think that's an interesting question, but I don't, in my mind, it's not dispositive of what we're talking about here today.
That's a good one.
You have heard what Commissioner McMullen has read into the record directly from what our rule says. And I have a second by Commissioner Northern, I think.
Yes.
No more discussion. All in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I propose the following conclusion of law and move that we adopt it. Title to the security deposit never vested in any party other than Mr. Gray. This is because the evidence in the record suggests that the conditions in paragraph 3 of the lease were satisfied.
Second.
Read that again.
Title to the security deposit never vested in any party other than Mr. Gray. This is because the evidence in the record suggests that the conditions in paragraph 3 of the lease were satisfied. My point is that it was always Mr. Gray's money. It was just a question of who had possession of it.
Had the motion made by Commissioner McMullen, seconded by Commissioner DeShara. Any discussion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries.
Mr. Chairman, I move that we make the following conclusion of law. No violation of TCA 62-13-312B5 occurred because the evidence fails to establish that the respondent did not account for or remit money in his possession that belonged to others.
Read that one more time, Commissioner McMullen. Please, sir.
No violation of TCA 6213-312B5 occurred because the evidence fails to establish that the respondent did not account for or remit money in his possession that belonged to others.
Second that.
Motion by Commissioner McMullen, seconded by Commissioner Collins. Discussion.
If we go back to the finding of fact, and I don't recall the number, but I think it was the second or third from the last two. Did that not speak to that?
What did the finding of fact say?
I'm thinking it said exactly the opposite, that he did maintain funds beyond, well, actually it did, because it, okay, I withdraw that.
Well, I think this is really the question that we have to address, and there can be differences of opinion, but really this is just a question of did he violate the statute, and that's what we're talking about. And to me, it's a close question, but I think you can legitimately listen to the evidence and decide that he didn't violate the statute.
I think it's a little bit more than that, because the statute is referencing earnest money. It's not referencing specifically security deposits. Security deposits are dealt with in landlord-tenant law. And in this situation, the agreement between the tenant and the management company controlled the security deposit, not our rules pertaining to earnest money. Our rules, I think, would speak more toward earnest money, but it doesn't speak toward contractual agreements between Mr. Hill and the owner of the property. And he's responding or reacting based on what he feels his contract says and what he says his obligation to the tenant is, which are both outside of our jurisdiction under the landlord-tenant law and under contract. This is not earnest money. But I think because the landlord-tenant law, because the individual is licensed with a real estate license, there is some responsibility to our rules pertaining to earnest money and or to funds being held. And personally, I think that the failure on his part to act created a violation. Now, the penalty, I don't think rises to the level that probably some of you others might think, but if I looked at the fact that he failed to take action after his contract was in dispute and after the tenant had vacated, that there is some responsibility on his part. But it doesn't fall under earnest money. It falls under landlord-tenant law with regards to security deposit. And his dispute with the owner under the management agreement is a contractual issue that we don't get involved in.
Well, can I respond to that?
Mm-hmm.
The section that we're talking about, which is 6213-312B5, I don't think it's limited just to earnest money. It says failing within a reasonable time to account for or to remit any monies coming into the licensee's possession which belong to others. And, the other here, I think, would be Mr. Gray. This was money that belonged to Mr. Gray, and it's a question of whether he failed to account for or remit those monies that were in his possession.
Accounting for, I think he did. The money remained in his bank account. There was never any dispute as to where the money was or whether or not he was using it for personal gain. Remittance is a different issue. And that's why I'm saying I think he should have done something. His lack of action, in my opinion, created some liability on his part.
But I would argue didn't we have a finding of fact that said Mr. Gray never asked for it? I think that's one of our findings of fact.
I think you did slip that in there.
I didn't slip it in there. It's a fact, man. That's testimony.
Well, and I think that goes to the question of, in interpreting the statute, remit to whom? because it says he has to have failed to remit any monies that belong to somebody else. And does the statute result in a violation if you fail to remit those back to the proper owner, which would be a little more constrained sort of reading, or should it be read more broadly to say that if you fail to remit that money to somebody else pursuant to the direction of your client, is that a violation?
But the money didn't belong to him. It belonged to the tenant. Right. Okay? His dispute is with the owner of the property. He's holding that money to hold the owner of the property hostage because he has a dispute with the owner. It wasn't used for damages. It wasn't used to offset any failure to pay rent. He kept the money simply because he wanted to make a point.
And a landlord can hold their own security deposit if they choose to.
If they choose to.
Now, that's your opinion. I think he kept the money because under his contractual agreement, he had to keep that money for the tenant.
Well, now
So
that's
why
not.
didn't he give it back to the tenant?
The tenant didn't ask for it.
But
So how was he? I mean, was he to hold on to it forever?
No,
At
It-
some point, he has to remit the money. It doesn't
And he
belong to
did.
him,
and he did.
and he didn't remit it to the tenant.
And in his email, he said, however, I can no longer afford to allow everyone to take advantage of my company without paying what they owe. He was holding that money because he felt like she owed him money. He also made a deal with her that if she would give him $250, he would release it.
And that has nothing to do with his obligation to the tenant.
Nothing.
And I think your interpretation is incorrect on that. I think the $250 was to release him from the management agreement. It
I agree.
It didn't speak
Well, I'm
to.
not saying that, but he held that security deposit as hostage. I'm like Isaac. I think it was being held hostage.
Well, he could have been more proactive. I agree with that, but I don't think hostage is the right word here.
I don't think it is either.
I think he was being held hostage.
We've got a motion and a second on the floor. Any more
Can we
discussion?
hear that motion one more time? I'd like to hear it. Make sure how I vote.
Not just messing with me. All right, this is the proposed conclusion of law. There was no violation of TCA 6213-312B5 because the evidence fails to establish that the respondent did not account for or remit money in his possession that belonged to others.
Motion and a second, and we've discussed it quite thoroughly. Any more discussion or comments?
Call for the question.
Question has been called. All in favor say aye.
Aye.
Aye. Opposed, no.
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 We have 5 yeses and 2 noes. Moving right along. Any more?
That's all the conclusions of law that I have.
Now,
There being a no vote, there's no penalty assessment, so.
Now.
Policy statement.
now we have to determine what kind of, what's my word here?
Policy statement?
No. What kind of
Discipline?
discipline? Thank you.
Well, there being no...
Yeah.
All right.
Typically, Commissioner McMullen's last comment, most boards would put that in the disciplinary section of their order. They would say that there was no violation of it, as your motion was, and therefore no discipline. And that's what I understood the board's action to be. So that would typically kind of fit into that category. There's no right or wrong way to do these things. We sit with about 75 different boards, and generally that's where they would stick that. So I think your next step is to make a policy statement.
Judge, I have a question, though. In his conclusion of law, we did find that the respondent was guilty of violating Tennessee Code annotated 6213-312B.
You're not making a determination that he was guilty. You're just saying that the law that applies in this case is this statute and this statute, and then the last action was to say that there was no, this set of facts applied to these statutes, there's no violation.
So this last conclusion of law was actually the disciplinary.
Well, that typically, the disciplinary section would say there's no disciplinary action is not appropriate because there's no violation. You could move that language into that area, but I think you're ready to just move on into the policy statement at this point. If, and let me clarify, I understand the board's vote, or the board's action on the last vote was that Mr. Hill did nothing wrong, and therefore there's going to be no disciplinary action. Is that correct? All right. So, policy
I
statement.
think he did something wrong.
Well, that's why you voted no.
That's the reason you voted no.
That's right.
Mr. Chairman, could I propose a policy statement?
Yes, Commissioner McMullen.
I move that we adopt the following policy statement. The statutes and rules relating to escrow accounts are intended to protect the public and the rightful owners of the funds held in escrow. In this case, funds held in escrow were safeguarded, and there is no dispute that the funds were turned over to the party entitled to the funds. Accordingly, dismissal of the complaint is appropriate.
You have heard Commissioner McMullen.
Second.
Read the policy statement that would go with this matter of
You want him to read it again?
Gaius Hill, number 12-18-119922A. You've heard the motion made by Commissioner McMullen and seconded by Commissioner Grease. Any discussion on the policy statement that Commissioner McMullen has read into the record? Hearing none, all in favor say aye.
Aye.
Opposed, no.
No.
5, let the record show we have 5 yeses and 2 noes. Your Honor.
Ms.
Judge
Ryan,
Darnell, turning it back over to you.
do you need clarification on anything?
Because I'm going to ask the respondent to draft the order.
Oh, well.
I'm serious.
Well, that's not his obligation. That's the agency's obligation.
But generally, when the party wins, and if we were in the courtroom, that's what would happen.
Well, the official action of the board is that order, so that's the we'll discuss that afterwards. So we don't need any clarification or anything at this point. All right. Anything further, Mr. Stevenson?
Unless you have anything, Your Honor, I think this concludes this matter, and also it concludes our second day of this March commission meeting, unless we want to go into any commissioner report.
And nobody's here to.
Commissioner reports.
There was one issue that I understood had been added to the agenda that we have not addressed.
Yeah. Okay, yeah.
It was a pleasure sitting with you. I came over. I didn't expect it was going to be such an interesting case. Turned out to be. Thank you very much.
We've had a number of law judges such as you through the years, and you've done an excellent job. We appreciate you.
Well, thank you. Don't talk about me when I get out in the hall.
It'll be on the record if we do.
Yeah.
Thank y'all.
Okay. Thank you, Judge Darnell. Thank you, court reporter. Hopefully you were able to transcribe properly, and good luck with the birth of your child.
When do you do? May. Close.
Number 5. Or 5th child.
What else do we talk about?
Okay, now, we haven't adjourned this meeting yet, and I'd like to turn the floor over to Commissioner Northern.
As I said, I thought I was told that there had been something added to the agenda that we haven't addressed. If I'm mistaken, then we can move forward. But Ms. Maxwell, did you add the issue to the agenda that I asked?
Yeah, we had that yesterday.
Okay. All right. As a little background, a licensee whose license is housed in Memphis, Tennessee, sort of in actuality in semi-retirement, lives in Texas, back and forth between the two. For whatever reason, license expired, and he failed to respond timely and received a consent order from the commission. He called and asked what it was about, and after he read it to me, I explained what I thought it was, and he said, well, is there any way that I can prevent having to come to the meeting? And as it's stated in the order, the only way that that could happen was for him to pay a fee of, I think it was $1,500. He said, well, is there a way I can oppose this? And I said, yeah, you can come before the commission. He said, well, I'm in Texas, and if it's possible just to have some notation put in the record that I would like to have redress with this, can that happen? I said, well, I don't mind asking the commissioners to consider allowing you to not come to the meeting, but it's up to the commissioners. And that's what I had asked to be put on the agenda. Not that he was trying, not that I was in favor of him not coming, but I had an individual who asked me to put it on the agenda and speak on his behalf, so that he didn't have to come up here and do this in person. And I said, I don't consider that to be unreasonable, considering the fact that when we put that motion, that policy in place, we said at that time that if an individual disagreed, he could come before the commission rather than pay the $1,500 fine. And that's where I'm asking at this point. I don't have I'm not presenting the details, but if you all are interested in hearing the details, I will present the details. Well, I'll have him submit something in writing to the commission so that his side will be heard. But I would remind you all that when we put that rule in place, the discussion was that not every offense led to the requirement of coming here to plead a case. And the response was, that's correct. Anybody wants to send in a request to come before the commission, or a request in writing to the commission, that it could be heard in that manner.
This individual, Commissioner Northern, he has no hesitancy about the penalty or that is being assessed. He just doesn't want to,
his point was, his offense was not that big a deal in his opinion. His license wasn't timely renewed for whatever reason. That's the fact. But when he found out about it, he paid to have it renewed, and that's when he received this agreed citation that said he had to attend the meeting or pay $1,500, and he thought the $1,500 was excessive, and the hardship of coming to the meeting was something that he would prefer not to have to deal with. So that's why he called and asked that I allow the consideration of the commission without him being here. Now, there was nothing put in writing because I never asked him to.
I just have a concern that we're setting a precedence maybe by doing that. I know that I had the exact same phone call from a different person, probably because this person doesn't live in Texas, but I'm just concerned that if we do it for one, what kind of precedents are we setting, and are we showing partiality by doing it for one and not others?
My initial thought was the same, but as I said, I went back to when we put that rule in place, and the rule was put in place for a different reason. This individual does not, in my opinion, fall under the objectives of that particular policy that we put in place, but it captured more than just individuals who had this rule was because we were talking about dealing with supervision and E&O issues at the time. Quite frankly, the man just failed to send his renewal in on time.
How much has he paid?
Whatever the renewal fee was.
And no penalty for, like other licensees pay?
No. And he's not saying that he shouldn't pay a penalty. He just says that the $1,500 is excessive for the
what would the penalty be? I mean, how long had his license been expired?
I can't answer that. Ms. Maxwell, can you speak to that?
Just to that issue? Is that all you want me to speak to? Just
Mm-hmm.
one issue?
I
About
can't
how long
hear
his-
you.
Do you want me just to speak to the one issue, how long his license has been expired?
Yeah.
Yeah, that was.
He paid $230. His license had been expired like 3 months. I thought I had the papers with me, but I don't. This man does have a residence address listed with us in Memphis, Tennessee.
I understand that.
Okay.
The gentleman that called me paid a $1,400 renewal penalty.
How long had his license
A
been
year.
expired? Okay.
He was right at the year. So, I mean, he had to pay that penalty. And he had medical condition. I told him where he couldn't sit all day. I said, so stand up.
So we require them to pay $1,500 or come to the meeting?
Correct.
What do we ask them to do at the meeting?
Sit here.
Out there or at the table?
No,
Out there.
They're just an attendee, licensee coming to the commission. Where did the $1,500 come from?
$1,500 is written into the into the reinstatement policy. If someone doesn't want to come to the meeting, then the way that they could opt out was to pay $1,500.
I have a
then you
copy.
could-
Would y'all like me to pass around? I only have one, but I do have a copy of the policy if you want me to pass
You
it
can
around.
read it, I would say.
Read the whole thing?
Just the pertinent part.
One of the conditions is either A, attend one regularly scheduled 2-day meeting of the Tennessee Real Estate Commission within 6 months of the date of the consent order. Licensees will receive 8 hours of continuing education credit for attending this meeting. Or B, in lieu of attending a meeting, pay a civil penalty of $1,500 to be paid within 30 days of the date of the consent order. Just after that, it says if the licensee seeking reinstatement executes a consent order but fails to complete any one of their requirements, an additional civil penalty of $2,500 will be assessed. So one of those two.
Is that for reinstatement for any reason?
For any license expired more than 60 days. Within the 60 days, it does not apply. And of course, if it's more than 1 year, they have to reapply for licensure and everything. So essentially, from 60 days to a year is the.
And that penalty was based on someone's desire not to have to attend the meeting, and the rule to attend the meeting was put in place, if I'm not mistaken, when we were dealing with supervisory problems with brokers and individuals who were in violation that we felt required additional training. Personally, that part of the rule, I think, probably needs to be reviewed, but it is a rule. I do understand that, and I understand setting a precedent. I'm just simply saying that he asked me to present it, and I'm presenting it. I think an individual has the right to have that done rather than having to come here and present it himself, or he can present it in writing. And in this situation, I told him that, I would present it to the commission and see what they would like for him to do.
How much time is he spending in Texas?
I don't know. He has a ranch in Texas, and he does retail site selections. Or in his last life, he did retail site selections for restaurants and things. But he's kind of semi-retired.
I don't have a problem with him submitting it to us in writing. Is that what you're asking?
I don't either, Commissioner Haynes, but
Well, now we're just talking about he said, she said.
this is the rule under which we're operating.
The reason I'm asking is that
policy.
He asked if there was any other alternative of staff, and they told him no. So he asked me if there were any other options, and I told him, well, I'll put it before the commission and see what they say.
Well, I wish I had more copies of this. I'd be happy to pass the whole thing around for y'all.
What's the date on that?
It was actually revised August 8th, 2012. We just revised a minor issue.
Right, we
then.
just, we changed the last paragraph. If you remember in 2007, there was a policy very similar to this, but you didn't have to attend the meeting as a condition precedent to reinstatement. You could attend the meeting within 6 months of signing the order, but we would go ahead and reinstate you upon payment of the money. And then in January of 2008, the commission asked us to look to see how many people had actually attended the meeting who had been reinstated, and less than 50% had attended the meeting. So the commission then changed the policy to make the attendance at the meeting and the payment of the money and the signing of the consent order a condition precedent to reinstatement. And then in 2012, that last paragraph was changed to read, a licensee seeking reinstatement of a license expired more than 1 year must reapply for licensure, meet current additional requirements, and pass all required examinations. Previously, that had said they may appear before the, may request to appear before the commission. And in actuality, they weren't appearing, and so it was changed to read the way it reads right now.
He ought to just have us out to the ranch for a meeting, and then it wouldn't be a hardship anymore.
Do what, Austin?
We could have a meeting at the ranch in Texas, and then it wouldn't be a hardship for him anymore.
Yeah, we go out there and eat some goat. Now, if we think that it's excessive, the $1,500 that's our policy, we can at any time address and lick that calf again.
Here's what I think.
But what do you?
I'm not asking us to make a decision on penalty. I'm just asking whether or not he can submit his request in writing without having to come before us for reconsideration of attendance or a lower penalty.
Well, sure, let him do it.
Yeah,
put it in
writing and send it to him for next month. Yes, Commissioner Grease.
It looks like our policy right now puts a value of $1,500 on attending this class. Attending this session, right? You can either pay $1,500 or come here for a day and a half. Right. So this session is worth
a negative $1,500 value.
Get
out of having to be here.
And I will point out that others have done that.
A lot of people
they
have.
paid $1,500.
Yeah.
Right.
A lot of people in my area have paid. They're going to be
just
mad.
so they don't have to come listen to
I thought
us.
you were going to start selling.
Yeah.
No.
Do what?
Commissioner Grease, yes, sir.
Recognize Mr. Pugh from Mississippi's got an update for us on the deal.
Where have we gotten with?
I say send a letter.
Somebody make a motion.
I make a motion that he sends us the...
Well, do it in your microphone, please.
I make a motion that he sends us a letter,
The gentleman from Texas.
The gentleman from Texas sends us a letter, and then we can consider it at that time. Right now, we just don't have enough information to even think about.
Do I hear a second to this motion? I have a motion by Commissioner Haynes, and seconded by Commissioner McMullen, and any discussion? Hearing none, all in favor say aye. Opposed, no. Mr. Wayne Pugh, if you'd start making your way toward the front, please.
We sometimes get like 7 to 10 written requests a week to not have to pay the penalty, not have to come to the meeting. Do you want all of those submitted to you all in letter form?
I wish you'd said that a minute ago.
How many a week?
You got to go pay? Go on. Come back.
We reinstated, I don't know why. Sometimes we don't, sometimes we don't get any, but we get a fair number of people who don't want to come to the meeting or don't, not for medical reasons, because the medical reason is a different issue, but who live out of state. We had a lady from North Carolina this past month, like this past meeting. But just, do you want, and that's fine, I can bring them all to y'all or send them to Bear.
Yeah.
You get that many requests for reinstatement?
We do. That's not every week, but we do some weeks. Some weeks get that many. Some weeks we don't get any. So we get a lot of them, and a lot of people they don't want to pay. They don't want to come to the meeting. Wow. So I just want to if we need to bring all of those, then I can send them to Bear. Send them. However you want me to handle.
That's what I'm afraid of. We're about to open a can of worms.
Yeah.
I just want to make sure we treat everybody like
that. You hit the nail on the head. I'm hearing the ghost of Charles Haynes. We need to treat everybody the same.
I just need to tell the staff what to do so that they know if they need to send a letter that we'll submit to you all, then it needs to be written to the commission proper.
Like I said, if we think that that's excessive, then we need to address that issue again, perhaps.
I think this is an unusual situation because as chairman of the Real Estate Commission has made the request, it's not like he sent the letter. I mean, so I think I'll honor the former chairperson from Memphis by voting so that he can call this guy back and say, they said you can submit it. Don't count on getting the result you want, but you can submit it.
Oh, we've already passed on that.
Yeah, well, I know, but that's all he's asking about the other dozen or so she gets each.
Well, I'm just asking about the ones that we get on a daily basis, whether you
Yeah,
want.
we're opening a can of worms
all,
here.
what I mean is, do you want all of those to come to whomever to look at or be read in the record? I mean, I don't know exactly what. I don't know how to
Somebody
handle
don't
them.
get that opportunity to write
I
a
wish
letter.
you spoke up before I made the motion.
Since you mentioned former Chairman Haynes, Mr. Stevenson, I also recall him saying that any licensee should have the right to contact the commissioner and make a request.
Oh, yes.
And that's all this man did.
Okay.
You carried that in here to us.
And I brought it before you. So if they simply if they simply send you all a letter, you can tell them, contact the commissioner.
No, I don't like that.
You don't like that?
I don't like that either.
Reese is the one to contact.
Grover Collins is it. David Flitcroft.
I mean, like I said,
Okay.
the guy just suck it up.
Moving right along. Wayne Pugh, can you
Well,
give
you haven't given Eve any direction here. She's needing direction on what to do.
Well, she's been handling things.
Well, no, but we've been telling people they have to. We tell people they have to come.
Have to pay or come.
Yeah.
Because the policy doesn't anticipate people coming beforehand. Eve has been telling them these are your two options. You need to either come or pay. And she's wondering now that this gentleman is going to be submitting information for consideration. In fairness to others, do they also need to be allowed to do the same?
Take back my.
Make a motion to reconsider.
Yeah.
Can I make a motion that we reconsider my motion?
I'll second the motion to reconsider.
Have a motion and second to reconsider. All in favor say aye. Opposed, no. Motion carries. Now where are we going?
I don't know.
Motion to tell him sorry.
There's no motion on the floor at this point.
I know, that's what I'm saying. Now where do we go?
Well, like I said earlier, I think we're opening a can of worms. I think that you've got to treat everybody the same. And if we let him do it, we're going to have to let all these other people do it. And the guy that called me, I told him, you either got to come or pay $1,500. That's your options.
Motion to put on the agenda for next month. Discussion of the existing policy and whether we ought to reconsider the policy.
I'll second that motion.
Very well stated, Commissioner McMillan, and seconded by Commissioner Haynes. Any discussion? Hearing none. All in favor say aye. Opposed, no.
But we still got to do something with Isaac.
No, he's still got time.
He's still got time.
Okay.
You need anything else, Miss Maxwell?
No, that's fine. I just need to tell the staff what we need to do.
Okay.
That's fine. We'll put an agenda for this.
Mr. Pugh, can you give us a quick update as to what you've been finding out the last day and a half?
I think we've worked it out on the E&O bill. I think everybody would be happy on that. So
I can't hear you.
Yeah, I got some.
It's on. Can you
got
hear
some
me?
hearing impaired commissioners up here.
I think we've worked it out on the E&O bill. I think it's going to be okay as far as they're just going to remove that section that deals with providing notice 30 and 90 days and just let existing law stand on it. So, which we've already comply with, so we're okay on that. Commissioner Haynes, on the fingerprint bill, it costs $42 if they submit fingerprints by electronic means, and it's $60 if they use a hard card. So you wanted that information.
One of the commissioners found out that they talked with someone that said that it didn't include, because we were talking about it being a logistics nightmare for the staff if all of a sudden all these current licensees had to submit 26,000 fingerprints and then somebody's going to have to look at them. But we had heard, why don't I let you, Commissioner Grease?
Just my discussions with TAR leadership, they indicated they're for this bill, they're pushing it, but their intent is for only new licensees to have to meet that requirement. I don't know if that's...
That's not what... And the new amendment that I discussed yesterday, I did notice after I spoke with you, it does not have a barcode on it. When they submit new amendments in the legislature, they always barcode them so you know what you're talking about. This one did not have a barcode on it, but it was handed to me yesterday, and it clearly shows the intent is that all licensees would eventually have to have their fingerprints done. New applicants have to do it prior to when they apply. Current licensees would have to do it at least once when they started to renew the license. So, and since we're in a staggered license structure now, it wouldn't be everybody all at one time. It would be as you got renewed.
Question? New licensees or every licensee has to submit fingerprints. The way you worded it earlier made it sound as if that individual is responsible for going out and finding an outlet that allows for fingerprinting and then providing it to TREC. And I'm assuming the reason or the rationale is to do a background check, a more thorough background check. But where does that come in this process?
A little unclear in the bill.
Y'all have a copy of the amendment.
Mr. Pugh, on this amendment, under 2.1, it says, provided, however, a licensee who requests to renew an existing license or obtain a broker's license after being licensed as an affiliate broker shall be required to submit a set of fingerprints if such licensee has submitted fingerprints to the Commission in a prior application for insurance or renewal of a license. That's the part that was amended, correct?
That is the part that was amended, yes.
But it still puts the responsibility of the individual submitting it.
Yeah, but that's the part that was amended to include everybody. Is that one right there was where the amendment was.
What do you guys do with it? Then do you run a background check? What does the department? What does staff do? What would they do with the fingerprints? Do they run a background check on everybody?
They'll throw you in jail.
Well, they already ran a background check on me.
So staff is going to be responsible for running the background check?
No. Yeah, I mean, that's
what I'm
question.
asking. What's the purpose of submitting them if there's no...
What you do, when you run the fingerprints, then you supply it to the TBI, who also supplies it to the FBI. They will run a report, okay? And on those reports, which are confidential, it's basically your arrest record and conviction record. And if you're doing the FBI, I mean, they're going to, if it's been reported anywhere in the country, it shows up on that report. And then you have that report that you can look at.
TBI sends it back to staff. Staff reviews it and takes action, or staff reviews it and puts it in the file? Or, I mean, where do we go?
The way the file is written right now is the Commission shall refuse to issue a license to an applicant or renew the license of a current licensee who does not comply with subdivision L1, which is providing the fingerprints.
But if they provide it and we've gotten beyond that,
I hate not having the clock back there.
Speak to that in this bill.
So we're just accumulating data with no...
Well, you already have some existing provisions under your law that if there's a conviction of certain crimes, that if they haven't reported it to you, there's an automatic revocation provision. And it is also a provision that if you are convicted, and it's been so long since I've actually dealt with this on a week-to-week basis, if you are convicted of certain crimes, that is a ground for disciplinary action, which you could revoke a license for.
I understand that, but the way it's written and presented is not complete. It just takes you to steps 1, 2, and 3, and it leaves you there. There should be a conclusion somewhere. In the law is what I'm saying, rather than just leaving it open.
And then is it up to staff to look at all these and compare it, make sure they check the right boxes, and then they notify you that...
Well, you get the report back from the TBI, and I mean, we look at these reports. The biggest program we have right now that does background checks are our security guard programs. And every time there's an application for a license that is run. On armed guards, they run both TBI and the FBI checks. And you get those reports back before they're ever licensed. You take a look at it, and in security guard, there are certain crimes that will prevent you from being licensed. I mean, it's a statutory prohibition from granting a license. So you look at those, and if one of those convictions is on that record, then they're prohibited from being licensed.
So the logical conclusion is staff is going to look at the report.
Somebody has to look at the
determine
report.
whether or not there's reason to deny or not renew, and
or take
go from
disciplinary
there.
action.
Okay.
But they end up coming before the commission.
Yeah, if
Really,
you're
I mean,
going to
like,
take
it was-
disciplinary action, it's going to
Right.
come before the commission.
We're
even
going
if-
we gonna start working more often then. Our $50 a day is going to add up quicker. We're going to have to meet twice a month, right?
Commissioner Grease.
So here's what I'm a little bit concerned about. Let's just take my case where I submitted fingerprints and they found a match. Now, there was no conviction, but there was a match. And so Kentucky Real Estate Commission wanted to know why the Knox County Sheriff's Department had my fingerprints on file. I've told many people over the years it's an honest mistake, but
Tell them it was your brother that did it.
if there's a match, is that an automatic trigger to get the applicant in?
And that the one thing about TBI and FBI reports, they do report arrest. So if there's ever been an incarceration and fingerprints are taken and you've given fingerprints, it will show up. Sometime, I'm not going to say a lot of times, but a number of times, there will not be a disposition of that shown on the record. Because in order to show the disposition, the court has to supply the record, and sometimes they just don't do that, and it does not get on the record. I know when we look at records for security guards, we are looking at convictions. If there's no conviction, then we're not going to really take into consideration an arrest. Because all an arrest is there was an allegation made at one point.
My point is, looking at a few security guards is a whole different ballgame than looking at 26,000 licensees.
Actually, there may be as many licensees there.
Security guards?
Yeah, there are a lot of security guards.
Okay.
Does it just return a hit, like a hit? I mean, like I thought it just returned like if you had something that showed up, or
Well, yeah, I mean, if there is no record whatsoever, if you've never been arrested, I mean, yeah, we'll send a report back, say there is no record.
Like our Boy Scouts all did. That was something they did in Boy Scouts. Everybody got
Well, and I was
fingerprinted.
going to say, you're going to have a hit on yours just simply because you've been fingerprinted
we
before.
did that with Boy
But there's
Scouts.
not going to be any criminal background that's going to show up.
If you just did a fingerprint for a criminal background check with Boy Scouts, that would not show up
I think
on
we were doing it for identity.
identity.
That was anyway.
That should not show up on your TBI or your TBI report.
Commissioner
Your FBI or
Grease.
your TBI.
I was just thinking, in my Kentucky license, it was a paper copy I had to submit along with the application, and I wasn't approved until all those issues were cleared up. But electronically, I guess they just go to TBI?
TBI has a contract with a provider, an electronic provider, where you can go and do your prints electronically, and they're submitted to the TBI, directly to the TBI. It's much more efficient. That's why it costs less to do that than it costs to do the hard copy.
Quicker result, too.
It is quicker, yes.
You might have any...
The contract that you speak of, is that, we would be working under that contract or utilizing that contract?
We have an agreement with the security guard program, private protection, with the TBI, and it works under their contract. And they have rules that you really want to go to the scenario that everybody's going to go get electric.
So a licensee in Memphis can go somewhere in Memphis and get this done?
Yeah.
They don't have to come to Nashville?
Well, they do not have to come to Nashville. Yeah, yeah, they have a number of locations where they can go. And
like in Texas, they can go to PSI and have it done as well when they go take the exam or before they take the exam. Oh,
And here you
Get over there.
sorry. In Texas, you can go to PSI when you go take your exam. PSI, Texas is not the only state, but PSI actually has an arrangement where they likewise can run the fingerprints, and so that you can do it all in one, in one step. So it's not as cumbersome, I don't guess.
Pretty bad problem with a realtor.
Along these lines of legislation, I want, on behalf of this commission, to thank Commissioner Grease and his efforts yesterday afternoon in talking with TAR and lobbyists with TAR and trying to get everything resolved around this
And I want
the E&O bill.
The fact that you put me on the dog floor at the hotel is a sign of appreciation.
Okay, you won't be on the dog floor next month.
Okay, let's go home.
Anybody have anything else to come before the commission?
One question we didn't get resolved,
What's that, Commissioner Collins?
we talked around it, is an email a legal document if you had to go to Chancery Court? I'd like our staff to answer that.
Yes. Writing.
Okay.
And we put that in our rules and regs, did we not? That's what I thought.
There's a statute that presents the electronic
Electronic Transaction Act. Yeah, there's
Right.
Electronic Transaction Act that if you go and buy a new cell phone, most of the time that contract is totally electronic.
But we're talking about, I'm going to email Janet and tell her I no longer need her services. And that's the kind of thing.
I can tell you that in circuit court over here, that yes, that's generally considered notice and written notice for purposes of whatever it's entered. Unless there's a contract that says it has to be done a different way, it's been my experience that has been sufficient.
We'll pull some case law on that and let you know next.
But for people like Bear that doesn't use his machine, somebody else writes his email.
Better send me a letter. Anybody else have anything to come before this commission meeting? We will see you next month.